For reasons mentioned in the judgment, the appeal is dismissed.
Delivery of order. Item number 2.
The petitioners are allowed to go on bail of rupees 1 lakh each with 2 sureties of like amount, subject to certain conditions.
Of this one.
The petitioners are allowed to go on bail of rupees 2 lakhs each with 2 sureties of like amount.
Delivery order item 50 from supplementary list.
For reasons mentioned in the order, the prayer for bail is rejected.
Meet please, Your Lordship. Lordship, I beg to mention this I for listing at 2 o'clock. There's a minor correction which has to be done in Your Lordship's order.
My order.
Yes,
Okay.
obliged.
May please, Your Lordship, the item number 35, Lordship. Lordship, the charge submitted, Lordship.
You are withdrawing.
Yes, Lordship.
You are withdrawing.
Yes. I don't.
Heard Mr. N. Ahmed, learned counsel for the petitioner, who submits that, who prays for allowing the petitioner to withdraw the instant anticipatory bail application on the ground that charge sheet has already been submitted. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
I will mention item number 51 of supplementary list may be withdrawn, Lordship, as per the instruction of the parties.
What is your name?
Yes, Islam.
Heard Mr. A. Islam, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant criminal petition. The prayer is allowed. This criminal petition is accordingly dismissed on withdrawal.
With liberty, Lordship.
What liberty?
With liberty.
What liberty?
Highly press.
The petitioner seeks liberty to file an appropriate application before the appropriate forum. The liberty sought for is granted.
Obliged, Lordship.
May please. Lord, I make to mention item number 53 of supplementary list, admission item, my lord.
Item number?
53 of supplementary list.
Yes.
That may be taken up as the last item, my lord. Matter relates to Jimma, my lord.
Last item means
My lord, I'm praying for upgradation.
last item means after completion of all items, we will take it up. Your
Well,
prayer is allowed.
My lord, within the court hours, my lord.
No, you cannot make many prayers. We will take it up as last item. Even if your item reaches earlier, we will not take it up.
Yes, my lord.
Okay. Yes.
Obliged.
Lordship, I beg to mention item number 52 of the supplementary list. On the last occasion, that is on Friday, Lordship had informed that we need to annex the previous bail rejection order. We accordingly filed an additional affidavit on Friday itself. However, upon checking the record once, it has
Yes.
not arrived yet.
Call for the additional.
So if the matter may be taken up at 2, then we can bring up in the record.
No, we will call for the matter. From the registry, the additional affidavit will be called for. We will take serially.
Obliged.
May I please, Your Lordship, Your Lordship, matter came up before Your Lordship regarding the proceedings against a postal officer, my lord, for delaying the returning this fixed deposit, my lord. We have asked him many times, my lord, matter came up with Your Lordship. You have asked me that.
What is your prayer?
Mention, only to mention tomorrow.
What matter?
Because there is a proceeding is going on against him.
No, what is the matter? Criminal petition.
For listing tomorrow. I am the.
What is the matter?
Matter relates to the proceedings of.
Is it a
406
criminal petition?
against the government officials, my lord.
No, Mr. Bishwas. Is it a criminal petition? Then there are senior courts you have to mention before.
I have approached, court said that I cannot give. That is the problem. But your lordship assured me that you mentioned it. On that day, I prayed for interim stay, my lord.
No, when same roster is taken up by more courts, you have to mention before the senior court.
The problem is that this court is not allowing us. That is the problem. But if urgency is there, that is the problem, madam. If your lordship decline, I have got nothing to submit.
I cannot take it up because senior matters, senior courts are there. You have to make, that is you go as per the notification of the registry.
And
If-
that we have approached.
If
This-
senior court is rejecting, we cannot help you.
Obliged.
May it please your lordship, I beg to mention item number 10. On the concern of the other side, kindly pass over the method for the day, lordship.
Heard Mr.
A. Sharma,
A. Sharma, learned counsel for the item number
10. I'm appearing on behalf of Y.S. Mannan.
A. Sharma appearing on behalf of Mr. Y.S. Manan, who prays for an adjournment for the day. The prayer is allowed.
Lordship, can it be fixed on 13, lordship?
Registry will fix it.
Lordship, I'm on interim, lordship. Can it be?
You are on, this has come up for motion.
No, lordship.
Interim was granted, lordship. Again, it has come from the motion column.
Again, it has come up.
Yes, lordship.
Let the matter be listed again on 13th of March. The interim order shall continue till next day.
Obliged, lordship.
Much obliged, lordship.
Like to mention, lordship, item number 46, criminal petition number 166 of 2025. Senior counsel had to go out of station for some urgent work, so may the matter be kindly be adjourned.
Heard, Mr. What is your name?
G. Anthony.
J.
G. Anthony.
G. Anthony, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed.
Lordship, an interim order was passed by this honorable court.
The interim order shall continue
And we
till
have
next.
complied with the order and we will be certifying with the court with the certified copy on the next day.
The interim order shall continue till next day.
Obliged.
May I please, your lordship, my prayer is for listing anticipatory bail, lordship, today, lordship.
Senior courts, court number 3.
May it please your lordship. Lordship, I mentioned for withdrawing of the bail application, lordship. Regular bail application, lordship, because
Withdraw.
charge sheet has been submitted before the court below, lordship.
When?
Lordship, yesterday, lordship, I've been informed that charge sheet has been submitted.
When you want.
Lordship, today at 2, lordship.
Okay.
Highly obvious.
May I please, your lordship? Lordship, I would like to withdraw item number 36 and 37.
Why?
As per line instruction, lordship.
What is your name?
K. Mainuddin.
K.
Mainuddin.
Heard, Mr. On whose behalf you are submitting?
HR Chaudhary.
Your name, HR Chaudhary.
Yes.
Heard, Mr. K. Moinuddin, learned counsel submitting on behalf of Mr. H.R. Chaudhary, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application. The prayer is allowed. This anticipatory bail is dismissed on withdrawal. 36 and 37.
Nice.
Lordship, I would to mention item number 30 of daily post list. The matter has already been charge sheeted. Earlier interim was granted.
Now, what is your prayer? We will take it up when the matter is called for. Wait for your turn. You wait for your turn.
Bishop,
There is motion here, item number 4.
May it please your lordship. Lordship, this is a regular bail application, lordship, related to lordship NDPS commercial item, lordship. Will find the FI that is on page 15, lordship.
Investigation is pending.
No, lordship, charge sheet is submitted, but the lordship legal point to be discussed here, lordship, whether that I am coming later, lordship. Can you peruse the FI that is on page?
No,
15?
no, you come to the point. What is
Yes,
your
lordship.
ground?
Now, lordship, kindly come to the the charge sheet, the date of arrest of this petitioner. That is on page 17, lordship.
On what ground you have filed this bail application?
Yes, Lordship, I'm coming, Lordship. Because on 27th, Lordship, this petitioner has been arrested, detained in jail custody, Lordship. Now, after filing, after arrest, Lordship, he has moved and bail application that is on page 19, Lordship. That was rejected. Thereafter, Lordship got it.
Yes.
6-9, it was rejected, Lordship. Then, Lordship, can we come to the page 21, Lordship? Charge sheet.
Yes.
Can you see the Lordship date of Lordship submission of the charge sheet, Lordship? They shown, Lordship, it is 11/1/2025.
Yes.
But it has been seen on 16/1/25, Lordship. Apparently, it is placed before the court on 16/1/25, Lordship.
Yes.
Now, Lordship, my detention is completed, Lordship. 180 days completed on 15 January 25, Lordship. Because, Lordship, he was arrested on, Lordship, 19 and forwarded on 20, Lordship.
Order sheets will be required when the charge sheet was placed.
But
Unless-
charge sheet has been seen on 16.
Unless we go through the order sheet,
Yes, Lordship.
your submission cannot be appreciated.
But, Lordship, the rejection order, the subsequent, that is on page 5, Lordship, annexure 5, page 35, Lordship.
Yes. What rejection order?
Operative Lordship,
Yes, what is your submission?
my submission, Lordship, the charge sheet was not filed in time, Lordship. He is praying for default bail.
In the rejection order, on what ground your prayer was rejected?
Prayer was rejected. That is on page, Lordship, 38, Lordship. They said, Lordship, bail application received subsequent to the filing of the charge sheet, Lordship. This is not the case, Lordship. Why I'm submitting this, Lordship? He was arrested on 20, Lordship. The date will be count from the date 20, Lordship. Then, Lordship, on 180 days, when it is completed 180 days, that is on 15 January 2025, Lordship. Because his detention after section 57 of the CRPC said within 24 hours, if the investigation is not completed, the person should be produced before the court, Lordship. CGM, Lordship. Now, Lordship, CGM, on the order of the CGM, Lordship, he was detained. Now, may I submit, Lordship? When 180 days is completed, it is not the duty of the court to inform the person that your statutory period is completed on such and such date, Lordship.
Yes, Mr. Das.
The order sheet is required for Lordship. Moreover, Lordship, it is rejected on.
You may file objection also, written objection also,
Lordship,
if you wish.
Lordship.
It is the duty on the court, Lordship, on the 180 days, he has to be informed, Lordship, this petitioner. Because this accused, Lordship, who is in detention, Lordship, otherwise he could not get any information, Lordship. Enter submission of the charge.
Where is the law?
Law, Lordship, says Lordship, 180
Duty
days.
to
how-
inform.
Lordship, 180 days, how can he calculate, Lordship, whether he has charge sheeted, this case has been charge sheeted or not, Lordship?
No, do you have any authority to show
Only
that
that, Lordship, our High Court, Lordship, the placing of this Samsun Noor case, Lordship.
what it says?
That case, Lordship, regarding, Lordship, that 90 days and 60 days, when it is placed before the court, that day it will be considered as an, Lordship, the date of submission of the charge sheet, Lordship.
Yes, Mr. Das. What is your submission?
Lordship, the petition, the bail petition is 21/2024, Lordship. And charge sheet is submitted. on 11/1/2025. So Lordship, it is on 11/1/2025. So on that date, before that date, Lordship, he has to file a petition, Lordship. On that ground that he has not been, charge sheet has not been submitted, Lordship. It is on 21/2024. Much earlier, Lordship.
When the charge sheet was submitted,
According to this, Lordship, page 21, 11/1/2025.
The court below itself, Lordship, observed, Lordship, that
11/1.
11/1/2025.
at the same time, Lordship, top of the corner, Lordship, it has been seen on 16/1/25, Lordship. Page 21.
Where it is mentioned that it is submitted on 11/1.
Lordship, in the charge sheet,
Upper part, Lordship. Charge sheet number
Charge sheet is dated 11/1.
11/1/2025.
When it was submitted, actually submitted.
It need to be look into the order sheet, Lordship, when it is submitted.
Yes. Order sheets will be required.
Lordship.
The
But-
rejection order reflect, Lordship, it is submitted, Lordship. That rejection order, Lordship, kindly peruse this.
Where it is mentioned in the rejection order, that is what I am asking.
Yes, Lordship. Lordship, on page 15, third paragraph, Lordship. Page 35, sorry, Lordship, page 35, annexure 5. Third paragraph.
No, we will call for the records. We will verify it.
Lordship, you need to be verified.
Heard,
Because in-
heard Mr. B.
There is record already been, there's an instruction has been called by the Lordship, last occasion, Lordship.
Yes. Yeah. Mr. Das,
Lordship,
you were directed to seek instructions as regards
Lordship,
default.
I will take instruction then, Lordship.
No, on last occasion itself you were directed. Because there is an observation in the rejection order by the special court
Lordship.
that the charge sheet was submitted on 16/1.
After some time then, Lordship.
Whereas he had
36
completed 180 days on 15/1. You show me that, Noor, the case which you are relying.
Yes, Lordship, it's two cases.
You, Mr. Das, you go through, we'll take it up again
Lordship.
today.
Obliged.
And Mr. Chaudhary, you come prepared with the authorities on which you are relying.
Yes, Lordship, to judgment, Lordship, I place the Lordship.
Mention the para numbers.
Yes, Lordship.
Good idea. Peace out.
Then after some time, Lordship.
Okay.
Item 5.
May I please, Lordship? Lordship, application under 483, the BNS for grant of regular bail in connection with Mongoldo PS case number 14/25. Accused has been behind bars since last 50 days.
Since last,
50 days.
what is the offense?
Lordship,
336.
3162, 3184.
It is pending investigation. Case diary would be required. Heard Mr. S. Das.
Of the co-accused was granted bail by this honorable court. on
Heard
aspect-
Mr. S. Das, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Perusal of the case diary would be required for consideration of the instant bail application. Hence, call for the same. List this matter again on
On 18, Lordship.
18,
17.
17.
17.
Item 6.
I think the bill.
Also, as per official date, lordship 6/3, perhaps lordship, the escape of the treasury has not been received yet. Otherwise, last occasion,
Heard Mr. A.Z. Ahmed, Learned.
the last occasion also lordship, because at that time I could not lordship place the next date of the case, that is why it was not considered lordship. But next date is lordship 24/3.
It is a charge sheeted case
Yes, lordship. Charge sheet.
against, no, let the scan copy come.
POCSO is also there, Lordship.
Last two.
POCSO is there.
Yes, lordship. POCSO, because arises out of a lordship child marriage case, lordship, because at that time she was minor and certainly she lordship.
POCSO is there, then is it a joint petition?
Yes, joint marriage.
But there is no affidavit of the victim. Victim signatures are there.
Yes, lordship. Page number 18,
Page number,
1818.
no, this is a photocopy.
Lordship. Affidavit,
This petition is, joint petition is not signed by the victim.
lordship, in the Ogalatnama lordship, she signed. Lordship.
No, the affidavit,
Lordship is the authorized lordship I have written.
who has signed the affidavit? Who is Lal Bahadur Sheikh?
Yes, lordship, he is the husband.
No. Unless, then notice will, how will we know that this is a joint petition unless the signatures of victims is not there?
Otherwise, I am lordship filing that way, other petition also.
You, no, how you are filing,
No,
that is
lordship,
not,
there is a affidavit, lordship.
where is the affidavit
Lordship, there is an affidavit, it says
of the victim?
victim.
You file an affidavit. Heard. Mr. A.Z. Ahmed, Learned Counsel for the petitioners. The office note dated 6/3/2025 shows that the scan copy of the case diary which was called for has not arrived. Issue reminder for the same. Will you file an affidavit? Okay, Learned Counsel for the petitioner also sought leave of this court to file an additional affidavit. In this case, the leave is granted. Let this matter be listed again.
Because last two occasions, the case diary has not been received, lordship.
Again on March 24,
Before.
24
That
March.
this was fixed lordship. Prior to 1 or 2 days, because on that day case was posted.
20th of March.
Lordship have submitted the order dated 2025, Lordship. However, my complaint petition has been rejected, Lordship.
What petition?
Complaint petition, Lordship. I filed a complaint petition, Lordship, because madam, my vehicle has been taken away by some unidentified persons, Lordship, under the jurisdiction of Jaggery Police Station, Lordship.
Where is the
Order is
MP.
at page 18, Lordship.
you were absent?
Lordship, which step? At this stage, I am praying for a notice, Lordship.
Heard Mr. R. Fukon, learned counsel for the petitioner. This application under section 430, 442 of BNSS has been filed by the petitioner impugning the order dated 6/2/2025 passed by learned Chief Judicial Magistrate Moregaon in CR case number 1008/2024. Issue notice to the respondents. And call for the records of CR case number 1008/2024. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable after 4 weeks. Listen.
Obliged.
May please, Lordship. My lord, I am convicted under section 138 of NI Act, Lordship. Thereafter, I have preferred appeal, Lordship. In appeal, the sentence is state, Lordship, but I am on a condition that I am to pay 20% of the fine amount, Lordship.
Pay it. Where is the impugned order?
Impugned order at page 69, Lordship.
Now, what is your submission?
But notice may be issued, Lordship. In the meantime, this order may be stayed. Lordship.
Why? Why it should be stayed?
Because once I have made payment of 20%, it is an admission on my part that.
No, there is a provision that submission, that is not a right submission. There is a provision under section 148.
Yes,
Court may
provision-
impose. Why the court is wrong in imposing?
That is also not mandatory, Lordship. On the appellate court, the payment of 20% it's not mandatory.
So
Lordship.
court has exercised its jurisdiction.
Yes.
Where is the wrong? What is the wrong in exercising that jurisdiction?
Because, Lordship, the evidence does not support the prosecution, Lordship.
No, you are unable to convince this court. We will issue notice only. Heard Mr. M.I. Hussain, learned counsel for the petitioner. This. And that is an interlocutory order. Your revision does not lie. It has to be dismissed because the order which you are impugning
Yes.
is an interlocutory order. It will be dismissed. Any submission? We'll take it after some time.
Lordship.
I'm going to dismiss it. Why it should not be dismissed?
Lordship.
You can make submissions.
Fine.
This is a criminal revision petition, Your Lordship, against an NI order. Wherein, Your Lordship, the impugned order is at page 20. The learned court below, Your Lordship, has received, after receiving the complaint, took cognizance under 138 of the NI Act and issued summons, and accordingly the petitioner appeared hearing. Now, Lordship, on 29/4.
Where is the impugned order?
At page 20.
20.
20. Now, Lordship, the petitioner submitted the evidence, the examination in chief as DW1 in the form of affidavit. And same was being allowed, the copies of the affidavit furnished to the complainant and fixed for further DWs. And again on 26/7/2023,
the petitioner again submitted the evidence in chief of DW2 in affidavit, and this was also been accepted by the court and was also submitted and to the other side. Now again on 8/1/2024, when it was fixed for cross-examination, the other side raised a complaint orally that they could not submit in written. And accordingly, the court, based on the oral submission, they have expunged and rejected the earlier order, and they have removed the affidavit. They have asked us to not press the same. Now, the thing is that, Lordship, in this case, whether the court can review the own earlier order has been passed without being challenged. Now, Lordship, the court has taken plea of the case of Mandi Corporate Bank Limited, whereas, Lordship, in the Indian Bank Association versus the Union of India case,
Now you have preferred this revision against,
we have referred in the second sports also. The same was being rejected, devoid of any merit. And now we have come to this spot. Now, the Lordship, in the Indian Bank Association versus Union of India, in the para 5, it has been stated that the accused has the right to lead his evidence on affidavit, and hence the order of the learned court below is erroneous and hence liable to be set aside. It was clearly given a right to file an affidavit in NI cases also. So my humble submission, Lordship, may kindly stay the proceeding of the NI case till further orders and the else the records may be called for, Your Lordship.
now whether revision is maintainable against an order of,
Yes, Lord. For these also, I have a case law, Your Lordship.
show me.
Para 12 of this case has given us the permission to file a revision petition when the erroneous order has been passed by the lower court, even in the district judge also.
When is the date fixed before the trial court?
The next date is fixed. It's not handy with me, Lordship, at right now. The next date is coming.
When?
I can give the next date within 2 months. So,
Heard Mr.
Submission.
S. Ahmed, learned counsel for the petitioner. This application under section 442 of BNSS has been filed by the petitioner. Read with section 528 of BNSS has been filed by the petitioner, impugning the judgment and order passed by learned additional session judge number 2 Nagaon in criminal revision number 26/2024. Whereby the said revision was dismissed by the court on the ground of the same being devoid of any merit. Issue notice to the respondent number 1. The petition and call for the records of criminal revision number 26/2024 from the trial court, as well as scanned copy of the NI case number 21. And call for the record of criminal revision number 26/2024 from the Court of Learned Additional Session Judge number 2, as well as scanned copy of the case record of NI case number 21/19 from the Court of Learned. Which court NI case is pending?
Additional Chief Judicial Magistrate Nagaon. The next
London.
date is on 11/3, Your Lordship, tomorrow.
Additional Chief Judicial Magistrate Nagaon. Let this matter be listed again on 11th of April. The prayer for interim relief would be considered only after due service of notice on the respondent side. The petitioner shall take steps for issue. Steps steps for issuance of notice upon the respondent number 1 by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 11th of April. List accordingly. Yes.
May please your lordship, an application under section 528 will be under such lordship for paying for Jimma of the vehicle, track lordship, the commercial lordship. Thus,
Where is the rejection order?
the case 21 lordship.
Why it was rejected?
The lordship, the only the registered owner of the said vehicle as well as the real owner of the mobile handset and cash amount as none has been submitted any documents regarding the ownership of the sender. Lordship, only that.
What is the offense?
Lordship, the offense under section lordship 303 subsection 1 oblique lordship 317
Yes, Mr.
BNSS lordship.
Lordship, as if I look into the registered, sorry, Lordship, page 21, the registered owner is not, it cannot be ascertained.
Lordship,
So Jimma report is necessary, Lordship.
lordship page 19 lordship,
They should, if
the
they,
RC lordship.
if they have the document, they should submit to the IO, Lordship.
It's only direction lordship I submit across the IO lordship.
But in the here, Lordship, in the report is stated that it cannot be ascertained.
The lordship, the page 19 lordship.
Why have you not furnished the documents before the IO?
IO lordship. I petitioner approached lordship owner, but he said the order is necessary from the court lordships. Then he approached the CGM court, Sunit court. Some goods are loaded lordship, the page 20 lordship. Says on 6th December.
We'll call for a report from the IO. Heard Mr. N. Ahmed, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner impugning the order dated 22/2/2025 passed by learned Chief Judicial Magistrate Sonitpur in Tejpur PS case number 719/2024, whereby prayer for Jimma of the mobile handset and with SIM card as well as cash amount of rupees 32,890 was you are seeking Jimma of
So Lordship, the phase two, Lordship, the one full container vehicle bearing registration number NL
as well as vehicle as well as
the vehicle and one handset, mobile handset and cash amount.
vehicle bearing registration number NL01AF6996 was rejected by the said court. Stop. Let a report be called for from the investigating officer of the
Tezpur PS.
Tezpur PS case number 719/2024 as to whether the aforesaid articles are required for the purpose of investigation and whether Jimma of the same can be granted to the owner or not. Learned additional public prosecutor shall produce the report from the investigating officer. When
23.
let this matter be listed again on 23rd of March 2025.
Item 12.
Made clear. My lord, in spite of the stay order of your lordship, the trial court proceeded with the case and issued valuable warrant against the petition. That is my case.
Where is the stay order?
Stay order is at page 23. Start from 22. Relevant portion is at page 23.
Where is the impugn order?
Impugn order is at page 28, my lord. 28A is the type copy.
When the order was passed
This order was passed on 1912.
and when the stay was granted?
Stay was granted in the year 23, 16/10/23.
The stay is still operating.
Yes, my lord.
Okay. Whether court was informed about this?
My lord, we informed it, my lord, that reflects in the order sheet also. And that's why he observed. Now perusal, kindly peruse the fourth paragraph of the impugn order. Now perusal of the CIS Honorable Guwahati High Court revealed that the accused side has not moved their case for getting any date of hearing and thereby unnecessary causing delay in this case. My lord, the opposite party did not appear before the honorable court. That's why the matter has been listed. I was informed accordingly. My lord,
No,
only
it was
thing-
stayed not up to a particular date, but it was stayed
Yes, man.
till the pendency of criminal. What has happened to criminal petition number?
That is pending, my lord. They did not appear. In spite of the knowledge
Okay.
that we filed the
That is-
criminal petition
that
and
is
the
wrong.
case has been stayed.
Heard Mr. G. Bosho, learned counsel for the petitioner. This state is a party.
No, my lord. The NIA case, my lord.
Okay. This application under section 528 of BNSS 2023, read with article 227 of the Constitution of India, has been filed by the petitioner, namely Kobindra Narjari, impugning the order dated 19/12/2024, passed by learned judicial, who is
Civil Judge Junior Division.
learned judicial magistrate first class. What is the station?
Dhubri, my lord.
Judicial magistrate first class, Dhubri, in CR case number 23/2022, whereby the said court issued no bailable warrant of arrest against the present petitioner. Learned counsel for the petitioner has submitted that the petitioner has been named as an accused in the CR case number 23/2022, which has been filed by the respondent before the Court of Learned Judicial Magistrate First Class, Dhubri. Stop. It is submitted by learned counsel for the petitioner that the petitioner preferred a criminal petition under section 482 before this court, praying for quashing of the proceeding of the said case. Stop. The said criminal petition has been registered as criminal petition number 1131/2023. Learned counsel for the petitioner has further submitted that by order dated 16/10/2023, passed by a coordinate bench of this court in criminal petition number 1131/2023, further proceeding of CR case number 23/2022 under section 138 of NI Act was stayed. Stop. The learned counsel for the petitioner submits that in the said criminal petition number 1131/2023 is still pending before this court, and the stay granted by the court, by the coordinate bench of this court, by the aforesaid order, within bracket order dated 16/10/2023, is still operative. However, in spite of that, the trial court has proceeded with the CR case number 23/2022 in violation of the direction of this court. Stop. On perusal of the materials available on record, now how will we know that it is still pending apart from your submissions? We are not disbelieving you.
Yes, madam.
Okay,
That record may be called for at 2 months. Or anytime. If your lordship wants to verify.
Yes. Itu record to anymore. Criminal petition 1131/2023. We will, if it is found that it is still stayed, we will dispose of this application
Yes, madam. It can be displayed.
after some time.
May please.
12 half done ase, huh? Yes.
My lord, in this case, the practice file like NI case, my lord. And process was issued. Unfortunately, my lord, the date could not be updated after 20th October 22, my lord. And accordingly, for 4 days, my lord, the complainant remained unrepresented. And the learned magistrate dismissed the petition for default. Page 22 is older one. May read, my lord. Complainant is absent without step, perusal of record so that the complainant has been remained absent without any step since
20th, 10/22 till 29/23. 4 dates, malad, he is not absent, malad. But I have next malad the pages of my diary, malad. In fact, malad, due to oversight, we could not malad read the next date, malad. That was the reason, malad.
What is the remedy?
Malad, because malad, the learned magistrate cannot malad recall his own, malad. So lordship may restore the case,
We will issue notice.
malad.
Heard. Mr. K. J.C. Gore, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, Messrs. D.J. Pharma, impugning the order dated 29/2023. And you are approaching now.
My lord, actually, in the month of January, when the party came to my lord,
No, but the delay, why to exercise inherent powers when you are approaching after 2 years?
my lord, that's-
This is not a case.
that's true, my lord. But my lord, actually, this case, my lord, remain unnoticed, my lord. In the at the time
No,
of,
no,
my lord,
no.
at the time of view, when the complaint representative complaint came in to my lord to tally the pending cases, my lord,
This is
then-
not a proper case.
He can file fresh complaint also.
No,
There-
no, 138.
138 case.
Condonation petition will be filed.
Well, 520, my lord, 520.
But otherwise, we are issuing notice,
Fine.
but this is not a fit case for exercise of inherent powers. 20, order dated 29/2023, passed by the Court of Learned Judicial Magistrate First Class in CR case number 2586/2022, whereby the said complaint case was dismissed for non-prosecution. Issue notice to the respondent number 2.
Wait.
Respondent number 2 and 3. And call for the case record of CR case number 2586C/2022 from the trial court. The petitioner shall take steps for issuance of notice upon the respondent number 2 and 3 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Obliged.
Happy. My lord, we have challenged the my lord impugned proceeding that your lordship will find at page 25.
What proceeding?
Yes. My lord, this is my lord, lordship will find the vernacular at page 28.
Complaint case.
Yes.
On what ground?
But because this proceeding is the counterblast to the earlier two proceeding filed by the petitioner. my lord. Now, lordship will find the first proceeding filed by the petitioner. Lordship will find at page 12. Page 12, my lord.
Okay, what is which is the stage
Yes, next date is my lord of 1/3/4/2025
for?
for orders, necessary orders.
You have appeared.
Appeared. She is on bail and cognizance has been taken. Next date is my lord 3/4/2025.
And ground is that it is filed out of vengeance.
My lord.
Heard.
Another ground also there.
What other ground?
My lord, the complainant and the witnesses were present at the time of the my lord, taking cognizance, but only the complainant was examined. The witnesses who appeared was not examined under section 200. And basically it is a counter blast to the earlier two proceeding filed by the.
Heard Mr. M.U. Mandal, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner Narzina alias Narzina Khatun, praying for quashing of the proceedings of CR case number 375/2022, pending before the Court of London Judicial Magistrate First Class, Borpeta. The learned counsel for the petitioner has submitted that the said criminal proceeding has been instituted against the present petitioner out of vengeance and as a counterblast to the earlier two proceedings, two criminal proceedings filed by the petitioner against the respondent side. So issue notice to the respondent, since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to the said respondent. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 2nd of April 2024-25. Let also the scanned copy of the case record of CR case number 375/2022 be called for from the trial court list accordingly.
In then further proceeding.
There will be no proceeding because next date is on,
T4.
I have fixed it on 2nd of April.
Obliged.
May it please your lordship. It is a challenge to the charge sheet, my lord. Before going to that, my lordship, may turn to page 22, the FIR, my lord.
Page
22.
22.
22, my lord.
Yes,
May I read, madam?
yes.
Subject, my lord, request for verification of documents of few suspected dental practitioner of Hojai. We would like to bring it to your notice that few practitioner of dentistry practicing at various locations of Hojai district mentioned below have been giving treatments to the patient. We have encountered various cases along with their prescription which doesn't mention their qualification or registration required to the practice dentistry in the country. Kindly find the evidence and attach pertaining to their practice with this application. Therefore, we request to verify the above mentioned documents of this practitioner and do the needful, and it is suspected that these dental practitioners do not have the required documents and license to practice dentistry, my lord. Well, below, my lord. Additionally, it has been found that few registered dentists have enrolled themselves along with their practice, whose name along with the address are mentioned below. Number 1, my lord, Dr. Rano V. 1000 BDS, my lord, so and so, has enrolled to dentist Mohibul Haq. Well, I am Mohibul Haq, my lord. Has enrolled to the dentist Mohibul Haq, registered number so and so, suspected and to be verified from the Assam State Dental Council, my lord. And thereafter, my lord, police during investigation, my lord, arrested the petitioner, my lord, that your lordship will find at page 24 of the forwarding report, my lord. Page 24, my lord, the forwarding report, my lord. Ground of arrest, my lord, serial number 4 and 5, my lord. Various prescription and 2 numbers of seal have been seized from the possession of the arrested accused of Muhammad Mohibul Haq, and prescription prescribed to the patient have been recovered from the informant side. During the course of investigation, it is learned that a minimum qualification is required to practice dentistry in India. Assam is Bachelor of Dental Surgery BDS, awarded by a recognized university, where the arrested accused person doesn't have this qualification, as it was found after serving the notice under section 91 CRPC from OC Sir Rojai PS. So it is clearly found that he is not eligible and found to be fake dentist, cheated many people by practicing which might cause injury to the patient. The question arises, what leads to such incidents? Perhaps no single cause is apparent, but it is illegal as they force the document to be true. The increase in the number of the medical legal cases and for the same medical profession is come under the attack due to the negligence of a few dentistry or the work of the quacks, my lord. So here, my lord, while arresting him, my lord, the police, my lord, seized two documents, two things. One, the letterhead and one seal, my lord. Now your lordship will turn to page 42, the last page, my lord. The letterhead, my lord. Lordship, may kindly see, my lord. Page 42, my lord, annexure 12. Lordship found that, my lord.
Yes.
That Dr. Rano V. 1000, registered number so and so, BDS, BRS, practice in dentist and oral care, my lord. Now my name appears, my lord. Mohibul Haq, registered number so and so, DM, SPP, GIDMS, my lord. I never wrote, my lord, as a doctor, my lord. My lord, this diploma, your lordship will turn to page, my lord, page 18, my lord, 18, my lord. (18, 19), my lord. And the, my lord, the important one is at page 20, my lord, annexure 4, my lord. Page 20, my lord. My lord, name, mother's name, father's name, my lord. Qualification with particulars, my lord. Dental mechanic course, September so, my lord. Institute of Dental and Medical Science, my lord. So the petitioner before your lordship, my lord, is a dental mechanic, my lord. I never claimed to be a doctor, my lord. I never claimed to be a doctor, my lord. So the police during investigation, my lord, had gone to the, my lord, Assam Dental Council to investigate, my lord, whether my that enrollment number is correct or wrong. So how they can find in the Assam here, my lord, Dental Council, my lord, because I am not a doctor, my lord. I am only a mechanic, my lord. And the charge sheet, my lord, that stereophonic charge sheet, my lord, page 31. The operative part is page 32, my lord. Page 32. Page 32, my lord, 15th line, my lord. Only one line, my lord. In course of the investigation, accused Mohibul Haq was arrested in connection with the case and forwarded to the honorable court, my lord. In the charge sheet, my lord, nothing is revealed, my lord, against me, what I have done. But I have never claimed to be a doctor, my lord. I am only a dental mechanic, my lord. That is
No,
apparent.
but accusation against you is that you are practicing dentistry.
But so the police during investigation had seized this, my lord, letterhead. There are only evidence with regard to this, the seal and the, my lord, this letterhead, my lord. Letterhead, it clearly says, my lord, doctor is Rano V. 1000, my lord. And against him, my lord, he was
Your submission is that there is no accusation against you.
Yes.
No material.
No, nothing, my lord. Yes, my lord, there is a prescription is there, my lord. But what I do, my lord, this cap, my lord, in dental caps, my lord, that I write, my lord. But so far as dentistry is concerned, my lord, nothing I have given, my lord, and I have never claimed to be a doctor also, my lord. From the letter, it is clearly clear, my lord, what degree I had, my lord, a diploma degree, my lord. And the charge sheet is a stereophonic, my lord, nothing, only one line, my lord. During investigation, he was arrested, my lord. That much, my lord. And that doctor, my lord, Rano V. 1000, my lord, FR has been filed against him, my lord. Because, my lord, his registration number and everything is okay, my lord. I work under him, my lord. Every dentist has a, my lord, dental mechanic, my lord. In Guwahati also everywhere, my lord, the lordship will find that. So I have never cheated, my lord.
Yes, Mr. Das.
Let the notice be issued, my lord, and not scan copy of case, there may be called for me.
Yes. Heard Mr. India Datta, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, namely Mohibul Haq alias Mohibul Haq, who is praying for quashing of the charge sheet number 201/2024 dated 27/8/2024, which has been filed in connection with Hojai PS case number 88/2024 under section 419/468/471/34 of the Indian Penal Code. In PRC case number 1117/2024, which is pending before the Court of Learned Chief Judicial Magistrate, Hojai. Issue notice to the respondents. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by registered post with AD as well as by usual mode within 3 days from the date of this order. When is the next date fixed?
Next one, summon is yet to be issued.
Returnable on 4th of April. No, not 4th. On 21st of April. Let also the scanned copy of the case diary of Hojai PS case number 88/2024 be called for from the trial court. Whether cognizance has been taken?
No, my lord. Only my lord charge sheet has been leaved.
Okay, list accordingly.
Till then, my lord, if further proceeding, if.
After going through. Because court may not take cognizance if nothing is there. If, as according to you, there is no material.
Yes, my lord.
Then the trial court may even not take cognizance. We have to wait for that.
21st. I'm obliged.
If the petition has been filed seeking to recall the NBWA issued against the petitioner. Two petitioners before your lordship, they are both husband and wife. My lord, the case is that the petitioners were not named in the FIR. My lord, FIR may be seen as at page 11. Though they are not named in the FIR, but in the charge sheet, they have implicated as a absconder accused, my lord. Thereafter, summon issued. According to petitioners, my lord, they have never received any summon. And accordingly, my lord, they were absent in the proceeding and the NBWA was issued on, my lord, 20.
What is the offense? 302.
302, but my lord, kindly see the nature of allegation page 11, my lord, vernacular FIR. Lordship has been married, my lord. Page 11.
No.
Gosoria.
Where is the summons?
Summons, my lord, we have not received, my lord. In the FIR, my lord, page 11, in the bottom portion, two accused names were there, Sonaullah and Reza Ali. We are not named in the FIR. Page 11. My lord.
No, naming or not naming is not material. Question is whether have you received summons from the trial?
According to petitioner, my lord, we were in the we were in Jammu and Kashmir during proceeding, my lord, and never received any summon from the court. Now, my lord,
What is your name?
My name
Rezabul.
is Rezabul, and his wife's name is Matara.
Then summons were served on you. What is the next date fixed?
Next date is, my lord, 26/3. My lord, we are ready to appear, my lord, if a chance may be given, my lord, because the NBWA, my lord, we are afraid to.
And thereafter, bailable warrant was issued.
Lordship. Now, my lord, the FIR named accused Reza Ali and Rezabul are two different persons. But in the charge sheet, my lord, nowhere the
Okay.
Reza Ali is there. But it was,
There is a mention that you went to Kashmir.
my lord, I have annexed the voter list, my lord, page 27,
Heard Mr.
M. Ali.
M. Ali, learned counsel for the petitioners. Also heard Mr. D. Das, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioners, namely Rezabul Haq alias Reza Ali and Asmotara Begum alias Muhammad Ismitara, who are aggrieved by the order dated 28/10/2024 and subsequent orders passed in PRC case number 319/2024 by the Court of Learned Chief Judicial Magistrate Gwalpara, whereby summons were issued, whereby non-bailable warrant of arrest were issued against the present petitioner. Learned counsel for the petitioners has submitted that the petitioners never received any summons or any bailable warrant from the Court of Learned Chief Judicial Magistrate Gwalpara, as they went to Kashmir in search of livelihood stuff. It is submitted by learned counsel for the petitioner that the next date of PRC case number 319/2024 is fixed on when it
To 26/3/25.
26/3/2025, and the petitioners are ready to appear before the trial court. Stop. However, they seek some protection from this court as non-bailable warrant of arrest have been issued against the petitioners. On perusal of the records, it appears that the bailable warrant of arrest issued against the present petitioners returned to the issuing court with a report that both the petitioners went out in search of livelihood. However, by order dated 28/10/2024, in spite of the aforesaid report, the Court of Learned Chief Judicial Magistrate Gwalpara issued non-bailable warrant of arrest. Stop. Since the petitioners are ready to face the trial and are willing to appear before the trial court on the next date fixed, that is 26/3/2024. This criminal petition is disposed of with a direction to the above named petitioner to appear before the Court of Learned Chief Judicial Magistrate Gwalpara in PRC case number 319/2024 on the next date fixed, that is 26/3/2025. Stop. To facilitate their appearance before the said court, the non-bailable warrant of arrest issued against both the above named petitioner shall remain suspended till that date. With above observation, this criminal petition is disposed of.
Obliged.
I'm sorry, my lord. Really sorry, my lord. Cognizance was taken, my lord, and the next date is fixed on 5th of June, my lord.
Okay, it is long.
My lord.
Long date is
Long
given.
date, my lord.
So our date is before
Yes,
that.
my lord, that submission may be in record. Cognizance has been.
Cognizance, I have not mentioned anything. I have just oral.
Taken. Yes, my lord. In fact, my lord, I have also annexed that order. It's in,
Okay.
that's why, my lord. I'm really sorry.
Okay, no. On next date, we will mention about the.
May I please, your lordship?
Reason for it to BNSS anticipatory bail application in connection with United case number 162 of 2021, Lordship. FIR page number 16, Lordship. May I read?
Yes.
With reference to the informant Tushar Nagate, accused Shibang Paul. With reference to the subject cited above, I have to honor to state with that I opened my GST account with the help of the accused number 1 around a year back. But on 2020-21, I by somehow come to know that the accused has fraudulently and falsely sold taxable values of rupees 6 crore 35 lakhs 43,524 rupees by showing fake impute value of rupees 1 crore 71 lakhs 52,155 only in my name from my GST account by using the GST user ID password to several person IC contractor traders and etc. who are also knowingly and intentionally involved in the conspiracy of the said fraudulent act and equally liable as per law without my knowledge and consent. Photocopies of the relevant documents containing names and those contractors, traders involved in the conspiracy and annexed thereof for the convenience, Lordship. This is the FIR, Lordship. Here the FIR, in the FIR said that out of 6 crores 543 lakhs, 6 crore 35 lakhs 43,524 rupees, I'm showing fake impute value rupees 1 crore 71 lakhs 52,155 rupees, Lordship. So far as per section clause 3 of section 3, clause 3 of subsection 1 of section 132 of GST Act, Lordship. It's a bailable, Lordship. But the FIR is registered under section IPC, Lordship, which is non-bailable. So the petitioner is ready to appear before the officer in concern with the necessary documents along with GST's, Lordship.
No, there is
From the year 2020-21.
there is an accusation of forgery.
Yes, Lordship.
Forgery is non-bailable.
Not applicable, Lordship.
Yes, Mr. Das. Yes, Daddy.
So far allegation is concerned, that is a serious one, GST forgery,
But
in case of,
1 crore 73 up to 2 crores is available.
but here
And I will
allegation is
produce,
regarding
Lordship. We will
6
produce,
crore,
Lordship.
more than 6 crore.
What
And
is,
the FIR
what is bailable?
Yes, Lordship, as per clause 3 of subsection 1 of section 132 of GST bills, Lordship. Up
134.
to 2 crores, Lordship. This is 1 crore 71.
Read it.
Yes, Lord.
Here allegation is taxable value is more than 6 crore.
Now, impute is meant. Impute is 1 crore 71 lakhs. Yes, Lordship, yes, section 132 punishment of certain offences. Whoever commits or causes to commit or retain the benefit arising out of any of the following offense, namely supplies any goods or service so and so, issues any invoice or bill without supply of goods so and so, avails input tax credit using the invoice or bill referred to the clause B of fraudulently avails input tax credits. D, collections any amount as tax but fails to pay the same on the government beyond a period of 3 months from the date of on which such payment becomes undue, evades tax or fraudulently obtained from refund, and where such offense is not covered under clause so and so, as GH, Lordship. This is in clause 3, Lordship. In cases of any other offenses where the amount of tax evaded or the amount of impute tax credit wrongly availed or utilized or the amount of refund wrongly taken exceeds 100 lakhs rupees but does not exceed 200 lakhs rupees, with imprisonment for a term which may extend to 1 year with fine, Lordship. In GST bills 102, Lordship, page number. Clause 3, subsection 1 of section 132.
Which section you referred?
Clause 3,
You don't mention clause first, mention the section
132 of
132,
of GST bills, sir, 2017.
132 clause.
Clause 3 of subsection 1, Lordship.
One 132 clause 1 L Roman 3. No, but this is the offense where the amount is amount of tax evasion, then tax credit wrongly availed or utilized. Here, your accusation against you is that you forged documents and fraudulently and falsely sold tax value of rupees so and so. Yes, Mr. Das.
My allegation is not very serious, my lord. He has shown it is that 1 crore 71 lakhs, that is a fake input.
Heard Mr. G. Fukan Learned. We are calling for the case there.
I'm fully cooperating with the investigating officer, Lord.
Heard Mr. G. Fukan.
I have objection to interim order, my lord. This is an economic offense.
I will fully submit.
No,
document,
when
Lord.
can you produce the case diary?
This is Junai, no?
Jonai.
Junai, it will take some time.
Heard Mr.
At
G.
least 10
Fukan
days.
Learned Counsel for the petitioner. Also heard Mr. D. Das Learned Additional Public Prosecutor. This application under section 482 of BNSS has been filed by the petitioner Bamang Se, who is apprehending his arrest in connection with Jonai PS case number 162/2021 under section 120B/420/468/471/406 of the Indian Penal Code. The accusation against the present petitioner is that on 28/2028, one Tushar Engate, Ngapey, Engate lodged an FIR before the officer in charge of Jonai Police Station, inter alia, alleging that the present petitioner had fraudulently and falsely stole taxable value of rupees 6,35,43,524 by showing fake input value of rupees 1,71,52,155 in the name of the informant from his GST account. Stop. Learned counsel for the petitioner has submitted that though the present case has been registered as under BNS, under various provisions of BNS. However, the offense alleged is an offense under section 132 of Goods and Services Tax Act, GST Act of 2017. He submits that as per section 132 within bracket 1 within bracket Roman 3 small 3, the alleged offense is punishable with an imprisonment for 1 year and with a fine which may extend to 2 lakhs of rupees. And therefore the offense is a bailable offense. Stop. On the other hand, learned additional public prosecutor has submitted that the perusal of the case diary would be necessary since the offense alleged is an economic offense involving huge quantity of money. Stop. This court is of considered opinion that perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Fixing
On 20
20
March.
for case diary. After perusal of the case diary.
Interim petition is referred to the accused person, he will come fully cooperate with the investigating officer, Lordship, because her name is not in the FIR, Lordship. FIR name is another person who was Ibang Paul, not in my name, Lordship. I'm only the trader, Lordship, or the farmer, Lordship, and MS BM Enterprise in my name, Lordship. I'm not in the FIR name, Lordship.
What is your name?
My name is Bamang Chai, and enterprise is MS Enterprise, Lordship. I have annexed my
Who is Chibang Pal?
Shivang Pal is the CA who is residing at Dhemaji, Lordship.
Stop.
I am from Arunachal Pradesh.
Since, in the meanwhile, since the petitioner has not been named as an accused in the FIR, the petitioner is directed to appear before the investigating officer of Jonai PS case number 162/2024.
My lord, my lord,
162.
one second. My lord, your lordship may kindly see the allegation, though his name is not in the FIR, my lord, case 16. Only in my name from my GST account by using my GST user ID password to several persons, that is contractors, traders, and etc.
Maybe,
But
Lordship, but the
the
allegation particularly for Shivang Pal.
allegation is against Chibang Pal.
Shivang Pal, Lordship.
He misused.
My lord,
He sold it to
Maybe, Lordship.
maybe to the petitioner.
But I will fully cooperate with the investigating officer along with my GST
Appear
case,
before
Lordship.
the investigating officer of Jonai PS case number 162/2021 within a period of 7 days from the date of this order and cooperate in the investigation. If she does, the petitioner is a lady.
Yes, Lordship.
If she does so within this stipulated period of time, in the event of her arrest in connection with the above noted case, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. List.
then it will be fixed on 28th of March.
List on 28th of March. Upper date to 20.
Same, Lordship. Item 18 and 19 are also same, Lordship. Petition is another. One Nabam China and another is item number 19 Techi Album, Lordship. This is
Same.
yes, Lordship.
Same FIR.
Same affair, Lordship.
Same PS case number.
Same PS, Lordship. And these two accused persons also not named in the affair, Lordship.
So you were the purchaser. It was sold to you.
Maybe may not be, Lordship. All about known by Shivang Paul, which was already arrested by the investigating officer.
18 and 19 same order. Same order. Petitioner naam to change kore diyo.
Apply. Hardly.
May I plead with Lordship? My lord, in the para number 4, there is some typographical mistake. May I, my lord, may we allow to file an IA petition for correction?
Okay. Third, Miss
It's Z Daisy.
H.G. Daisy, learned counsel for the petitioner, who prays for allowing the petitioner to file an interlocutory application for praying for correction of certain typographical mistakes which has crept in the bail application. The prayer is allowed. The petitioner shall do so before the next date fixed. Let this matter be listed again on when?
17, your lordship.
On 17th of March.
Apply here.
Item 21.
May please, Your Lord. Well, this is an anticipatory bail application matter. FIR matter is at page number 13. May I read the FIR?
What is the offense?
Offense has matter, any false manner, wrongful restraint manner, assault manner,
Assault
yes, unlawful assembly manner,
and grievous injury.
yes. May I read the FIR?
Yes.
With due respect, I beg to state that I, Jituboni Bora, have been working as a bodyguard with the respected Tripuri Lok Sabha constituency MP Rokibul Hussain since last 25/10/2024. That today on 22/2025, I along with respected MP with his son Tanzil Hussain and with one of his friends went to the Gunabari Village Congress Party's meeting out within the Rupohiat police station jurisdiction with their car. After reaching the Rupohiat High School, we got down from our vehicle and we went to one of the vehicle village under Rupohiat police station with two motorcycle of our party members. While we were going for the meeting at around 2:30 p.m., 20 to 30 miscreants carrying hockey stick forcefully stopped us at Notun Bazar and took away keys of the motorcycle on which our respected MP was riding. Looking at the incident, we tried to protect our respected MP, and in doing so, those miscreants threatened to kill us. We saw that our respected MP was in a situation where he has been pushed and pulled also. Few miscreants beat our respected MP, and in doing so, we have opened 2 rounds of fire in the air in our defense. After open fire, which was meant to safeguard our respected MP and us, we then sent our respected MP to the place of the meeting where he was traveling in the first occasion. Thereafter, few miscreants hit us with their hand along with hockey stick and brick. Also, in doing so, the miscreants forcefully tried to take out the carbine of our issued weapon from my hand. At that time, the officer in charge of the Rupohiat police station came to the place of occurrence and rescued us from such miscreants, and thereafter took us to the Gunabari meeting in their vehicle and after dropped us to protect our MP. Thereafter, the officer in charge of the Rupohiat police station took us for medical examination. Meanwhile, our issued weapon was seized by the OC of the Rupohiat police station and later was given Jimma of the said weapon. We don't know who those miscreants were, but if we see them, we can identify them. Now, what's it? My humble submission is that the entire incident was videographed, my lord. So if these persons are allowed to appear before the IO, my lord, then the informant can definitely identify from the videography, my lord. Because at this stage, my lord, nobody can identify, my lord, these persons are not named in the FIR.
Then why are you apprehending?
Apprehension, my lord, because police are searching for us, my lord. We are residents of the nearby villages. Some may be passerbys, some may be, my lord, bystanders.
No,
my
no,
lord.
police may be searching
Yes.
because police might have got some clue.
Yes, but my lord, even if we go by the what is written in the FIR, so lordship will kindly see the vernacular, my lord, at page number 17. Last line.
No, you assaulted.
দুর্বৃত্তর দলটোক আমি চিনি পোৱা নাই, দেখিলে চিনি পাওঁ। So my lord, let him identify, my lord. Let some identification be done. Identification parade can also be conducted, my lord. But at this point, my lord, at least this person should be allowed to appear, my lord. So from the video, my lord, let the informant identify them, my lord. If he identifies them, my lord, case there will reveal.
No, but the accusations are grave.
Yes, that I admit.
So merely because you appear before the IO without any protection.
Because some may be, my lord, some may be innocent also, my lord, because lots of people were there at that point of time, my lord. Some may be bystanders, some may be onlookers, my lord. Some may be
Oh,
actually
how
involved.
many petitioners?
Petitioners, my lord, are 10, my lord, 10 petitioners.
Because out of these 10,
Yes,
3 may be main miscreants.
yes,
7 may be
yes. So,
innocent.
so the case there will definitely reveal, my
Case
lord.
diary has
Yes.
to be looked into.
But without their appearance, my lord, he won't be able to identify and police also won't be able to identify that.
Yes, Mr. Das.
Well, I can produce the case diary
When?
any date according.
Let us go through the case diary.
Perhaps case diary this, Rupo here, no? But there are many cases of this, like in taking this incident of MP Rokubul Hussain. Rokubul Hussain case diary.
But without perusing the case diary,
Well, yes, perhaps case diary is there in connection with other cases, some other petitioners are also.
There are two FIRs, my lord. One by the MP himself and another by the PSO. This one is the PSO.
about the same incident.
Yes.
Well, let it come day after I will, if the case there is there, my lord, we will produce
Okay.
on that.
Okay. Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by 10 numbers of petitioners who are apprehending their arrest in connection with Rupohi Hat PS case number 67/2025 under section 189 within bracket 1/189 within bracket 2/190/126 within bracket 2/121 within bracket 2/117 within bracket 2/132 of BNSS. Considering the nature of accusation made in the FIR, this court is of considered opinion that perusal of the case diary would be necessary. Learned additional public prosecutor submits that the case diary might have been called for in connection with another case of same nature. He therefore submits that he will verify from the office of the public prosecutor and prays for listing this matter day after tomorrow. That is on 12th of March. List this matter on 12th of March for case diary. 12th.
Highly obliged.
I just repeat you from supplementary.
Lordship, may the matter be passed over for the day,
Passed over for the day.
due to personal difficulty of senior counsel,
Heard Mr.
P.D. Chaudhary.
P.D. Chaudhary, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting senior counsel for the petitioner. The prayer is allowed.
My lord, may the matter be taken up on 13th, if not then on 18th,
18th.
either 13th or 18th.
Let this matter be listed again on 18th of March.
Obliged, my lord.
Okay. Bail hearing.
Bail hearing create. Item number 25.
My lord, kindly pass over a matter for time being, lordship. For time being.
Item 26.
Maybe a motion. NDPS madam, CD was called for individual custody for last 129 days, madam. CD was called for 3 times, madam, already.
CD is not there.
It is not received, my lord.
Well, here it is.
So one more chance, my lord. I'll produce the case. Let it be come on Friday, my lord.
Friday's holiday.
Friday, holiday, Monday, my lord.
Monday,
Monday.
next Monday. Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. A.F. N.U. Mullah, learned counsel for the petitioner. Also heard Mr. R.J. Burwa, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this matter be listed again on 17th of March 2020.
Item 27.
Yes.
The accused behind the bar 165 days as on today, my lord.
What is the date of arrest?
Date of arrest is 26/9/2024.
26/9/20.
2020.
Be louder.
26/9/2024.
24. Yes. What is your case? What is the ground for which?
Your Honor, 18 inches of simplex was containing 432 capsules were recovered.
Yes. What is your ground? You are not ready.
My lord.
Not ready.
No.
Then I will dismiss it. Should I dismiss it or you?
Date,
You have to make some submission.
Fix another date.
Okay. CD is there.
If there is received, my lord, investigation sufficiently progress, my lord, but it is only pending to collect the FSL report, my lord. So I may be allowed 1 week time, my lord, or Rosie may dispose of the bail application. It is recovered from his possession, my lord.
What is your submission? Heard, Mr. What is your name?
TT morning.
T.T. Moni, learned counsel for the petitioner. Also at Mr. R.J. Burwa, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Mukhtar Hussain, alias Mukhtar Hussain, who has been detained behind the bars since 26/9/2024 in connection with Gwalpara PS case number 129/2024 under section 22C/29 of the NDPS Act. The gist of accusation in this case is that on 26/9/2024, one Lalchand Ali Ahmed of Gwalpara Police Station lodged an FIR. No, not Lalchand Ali Ahmed. One date alag hoga. On 25/9/2024, one Gitartha Kolita, SI of police, had lodged an FIR before the officer in charge of Gwalpara Police Station, inter alia alleging that on receipt of an information through reliable sources, as a search operation was conducted, and during search, conducted at Hidayatpur, and during search operation, two persons, namely Khalid Hussain and Anwar Hussain, were apprehended no, not Khalid Hussain. Two persons, namely Mukhtar Hussain who are the accused persons, and Shahinur Hussain were apprehended, and from their possession 18 strips of Sempex Plus tablets containing 432 numbers of capsules were seized were found in a polythene bag. Learned counsel for the petitioner has submitted that the petitioner is innocent and in no way involved in this case, and he has been detained behind the bars since 26/9/2024. On the other hand, learned, is it commercial quantity?
Commercial, my lord.
Learned additional public prosecutor submits that has produced the case diary of Gwalpara PS case number 129/2024 and has submitted that there are sufficient incriminating materials against the petitioner in the case diary. And as the quantity of contraband seized in this case is of commercial quantity, hence, the embargo of section 37 of the NDPS Act is applicable in this case. So I have considered the submissions made by learned counsel for the parties and have gone through the materials available on record. On perusal of the case diary, it appears that there are sufficient incriminating materials against the present petitioner in the case diary. And as the embargo of section 37 of the NDPS Act is applicable in this case, the prayer for bail is rejected. Send back the case diary.
Item 28.
Please, your Lord. Can copy was stopped. Where it has come, the question is that, but who is the petitioner sir belong to the road transport? And the vehicle truck which was detected by the police with the tablet belongs to our organization, madam. And there is allegation that we, these two persons, following the truck, behind the truck, and that's why we are suspected that we are involved in this transportation of the tablets.
Where
Now,
is
we have annexed the agreement deed also, my lord. That is there also. That is there. Your lordship will consider it. And in fact, we are arrested, my lord, on 6/4/24. And case was charge sheeted, my lord, in the month of September. I take your lordship page 22. But till today, no charge was framed.
when were you arrested?
6/4/24.
For how long you are behind the
Now, my lord, till today, 339 days. Charge sheet was filed, charge was not framed. No question of evidence doesn't arise. We have filed a petition before the court below that we are the owner of the transport. We have nothing to do what the court will take action against the truck. The truck has been held up by the police and the driver was arrested. And we have been suspected because we are coming behind the truck.
What was seized?
It was a Yaba tablet.
It is a huge number of.
Yes,
Yeah,
huge
but
number.
it's a 10 packets
10,000.
and more than 10 crores.
It
It
is
was a valued.
So
about-
your submission is that you don't know what is, you are innocent.
It was not recovered from me, it was recovered from the truck. With these two persons who are behind the truck.
You are the owner of the truck.
Owner, no, we are owner of the transport association. The truck belongs to transport authority company. Belongs to our company.
In IO report also, my lord, one IO objection report has been given to me to file.
Just a minute. Let him complete. What else is your ground?
My ground is that till today, first we are not involved in the case because we are the owner of the transport. And it was not recovered from our physical position. We are no way connected. The only imagination of the IO that we might have been involved because why we are following the truck.
There was a statement also in the CD actually.
And moreover, my lord, after 321 days, case was charge sheeted. What prevented the prosecution to frame the charge? What prevented thereafter to proceed with the trial? So to my humble submission, court detention is illegal, unauthorized, and I deserve the bail, my lord. I am ready to face the trial. If anybody accuse me that I am involved in carrying the goods, these tablets, the child will be convicted.
Yes, now you say.
They confessed, both the accused has been confessed already that they were involved in the tracking this illegal smuggling of Yaba tablets. Already search sheet has been submitted and trial is going on, my lord. And they are from Tripura.
Yes.
Accused are from Tripura. If they were enlarged in bail, they might be
No,
cooperated with
no, before that, what materials are against them?
They were also involved in the smuggling racket. Already they have confessed all.
Confession to POCSO.
There is a huge quantity, commercial quantity, valued more than 10 crores, my lord.
No, that is not enough. Their involvement you have to point out. Heard Mr. S.C. Vishwas, learned counsel for the petitioners. Also heard Miss, what is your name?
P.S. Chakravarti.
P.S.
Special
Chakravarti, learned special PP DRI.
Here.
This application under section 483 of BNSS, 2023 has been filed by the petitioners, namely Uttam Sarkar and Bahar Mia, who are detained behind the bars since 6/4/2024. And in connection with
DRI seizure case number
120.
01/CL of the NDPS DRI seizure to 2425.
no special case has yet been registered.
No.
In connection with DRI. DRI case number 01/CL/NDPS /DRI/SIL/2024/25 under section 21C/29 of the NDPS Act. The gist of accusation in this case is that on 6/4/2024, a complaint was filed under section 21C/29 of the NDPS Act by the Directorate of Revenue Intelligence against three numbers of accused persons, named including the present petitioner. inter alia, including the present petitioner, stops. In the complaint, it was alleged that acting on a specific intelligence input, the officers of DRI Regional Sub-Regional Unit Silchar, assisted by BSF personnel, intercepted one Alto K10 VXI car bearing registration number ML05Q 6151 and one Tata truck bearing registration number AS01FC 0271 at 6:30 hours on 6/4/2024 at Kalain area of Kachar district. Stop. The in the car, next para, in the car, in the Alto car which was intercepted, the present petitioners were found to be the occupant. The car was being driven by the petitioner number 1, Uttam Sarkar, and Baharmia was the other occupant of the said car. Whereas in the truck which was intercepted, one Nauren Arun Singh was found to be driving the said car, said vehicle on search made by the DRI official 1 lakh numbers of suspected Yaba tablets containing methamphetamine were recovered from the said vehicle. The total quantity of the seized contraband was 10 kg. Now, learned counsel for the petitioner, Mr. S. Vishwas, learned counsel for the petitioners, has submitted that the petitioners are innocent and are not involved in the offense alleged in this case. He submits that nothing was recovered from the vehicle in which both the petitioners were found. Their vehicle was only following the truck from where the recovery was made. What else is your submission?
But it was recovered from the truck. There was a
Anything?
cabin inside. It was kept concealed in the cabin as per report, madam. But we were also going Tripura. Their truck is also going Tripura. So we are behind the track, madam. And police suspected us that we might be involved in this connection. Otherwise, why we are following the track? We are taken to the police station. We have been tortured like anything. And now 324 days we are behind the bar, without trial, without framing of charge.
Learned counsel for the petitioner have also submitted that there is no material on record to link the petitioners with the offense alleged in this case.
339.
And they were arrested in connection with this case merely on the basis of suspicion. On the other hand, learned Special Public Prosecutor, Ms. P.S. Chakravarti, has vehemently opposed the grant of bail to the present petitioners on the ground that there are sufficient incriminating materials against the present petitioner on record. She also submits that the quantity of contraband seized in this case is of commercial quantity, and therefore the embargo of section 37 of the NDPS Act is applicable to this case. You take the scan copy of the record, flag where you find that there are some incriminating materials against the present petitioner, and then give it to me. I'll dictate remaining part in chamber. If there is material against you, then bail is rejected.
Except their confession. We have confessed. Your lordship knows the
Okay.
value of confession
Okay.
before a police officer.
Apart
Or
from
the-
confession, what material is there you have to
Yes.
find out?
Only thing what I pray, my lord, that case remain without framing charge. 339 days. And without even, so no charge was framed, question of summoning witness also doesn't arise. How long? They have not, the learned session judge has not considered that
Ek
aspect.
line or likhna. Learned counsel for the petitioner has also submitted that the petitioner has been detained behind the bars
339
for
days.
last 339 days. And till now,
No charge was framed.
the trial has not yet begun. And therefore, on the ground of prolonged incarceration also, he has prayed for allowing the petitioner to go on bail.
Regarding confessional part, your lordship knows the value of it. Your lordship will consider. I leave it to you, lord.
এই রেকর্ড তো দিব, রেকর্ড তো দিব, ফ্ল্যাগ করিব।
May I
Yeah,
please, your
item.
lordship. Allegations is against me is the theft, lordship. FIR is at page 13 and the type copy is at
Theft of what?
theft of some machinery items, lordship. HDD parts and some pipes, lordship. So
When were you arrested?
I was arrested on 6/2. As on the 33 days, and we are behind ours, lordship. 2%.
CD is there.
Case that is received, my lord. But whatever, my lord, the incident took place, my lord, theft took place, my lord, in the, my lord, practice sport PS area, my lord. Now, my lord, the stolen goods, it was recovered from Kajolgaon PS, my lord. Because stolen goods was, my lord, recovered, my lord, by the Kajolgaon police station, my lord, and the accused person were also arrested, my lord. Now, my lord, the goods has not been transferred from to my lord, practice sport police station from Kajolgaon. Because Kajolgaon police station has also from their side, my lord, investigating the matter, my lord.
Same matter.
My lord, actually, my lord, the goods recovered from another police station, my lord. That is the difficulty, my lord.
Lordship, what happened, lordship? If we peruse, lordship, page number 13, lordship, the FIR, which is not clear even what incident was took place, lordship. Even, lordship, I am unable to properly understand, lordship. The informant is 2 persons here, lordship. And in the forwarding also, police could not able to elaborate anything regarding the theft, lordship. So, lordship,
It will require some more investigation, my lord. That is why.
lordship, no problem.
No, what was stolen?
Lordship, that was.
These are some pipes, my lord. Pipes and some machineries, my lord.
According to the police who were investigating, lordship, they mention here that some machine, lordship. Actually, lordship, petition number 1 is the driver, lordship. Sometimes he used to drive
Where
the
is the
vehicle.
rejection order?
Lordship,
Bail rejection order?
lordship, I have not annexed and I have not approached, lordship.
You have not annexed
Lordship,
when it was rejected.
lordship, I'm not aware whether it was approved before lower court or not.
No, but that is the mandate
Lordship.
that where is your affidavit?
Accused person were also arrested by my lord, the Other police station, my lord.
So far concerned lordship, the type copy which I have, I could understand and I type lordship, may I read lordship?
No.
Page number
Before
7.
that, you have directly approached or your bail was rejected earlier. Because your affidavit is silent, there has to be a statement in the affidavit that informing this court regarding the fate of any bail application which has been filed by the petitioner.
Lower court or I may be, some time may be given.
On
After some
request,
time.
on request, not sometime, you have to file an affidavit. Otherwise, it will be dismissed. How it was passed by the registrar. Why are you not complying with the notification?
So no bail petition in respect of the accused person is pending lordship in the lower court lordship.
File person na kasi sir.
Okay.
File person na reject person to reject order to like.
Reject to
Huh?
reject
File করায় না।
file করায় নাই থেকে।
There is no such statement in your bail application.
11, point number 11 lordship, para number 11.
In the affidavit,
In the affidavit there is not. In the bail petition lordship, para number 11.
This is in respect of High Court.
Any other one?
yes, Mr.
My humble submission, my lord, the accused persons were also arrested by Kazulgaon police station, but later on, my lord, they were handed over to my lord, Pragjitpur police station, where they were interrogated, my lord. Only my
No,
lord, the
but-
goods were recovered, my lord, but whether my lord, these goods are exactly the same goods or not, my lord, or whether the complete goods has been recovered or not, my lord, that will reflect from the, my lord, further investigation only.
No, but 33 days they are behind.
33 days, my lord.
Lordship, as per
Let them cooperate, my lord, what I say, my lord.
so far information I obtained.
Because from the case diary, my lord, it reveals that, my lord, it will take some time, my lord.
Okay, heard Mr. S. Ali, learned counsel for the petitioner. Also heard Mr. R.J. Porwal, an additional public prosecutor. This application under section 483 of VNSS has been filed by the petitioners, namely Roopchan Ali and Muhammad Akbar Ali, alias Akbar Ali, who are detained behind the bars since 6/2/2025 for last 33 days in connection with Pragjyotishpur PS case number 8/2025 under section 303 within bracket 2/3 within bracket 5 of BNSS. The gist of accusation in this case is that 1. The two informant, namely Ved Prakash and Akmil Rashid Khan, had lodged an FIR on 1/6/2024 before the in charge of Panikhati police station, inter alia, alleging that the petitioners have stolen HDD pipes, HDD parts in one golden ring. Stop. Learned counsel for the petitioners has submitted that the petitioners are detained behind the bars since last 33 days, and considering the period of detention, they may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Pragjyotishpur PS case number 8/2025, and has submitted that some of the stolen goods were recovered within the jurisdiction of
Kajolgaon Police Station.
Kajolgaon Police Station
District of Sirang, madam.
in the district of Sirang. And an investigation is also going on by that police station. He further submits that he opposes the prayer for bail at this stage as further investigation as the investigation is going on. So I have considered the submissions made by the counsel for both the sides and have perused the materials on record, including the case diary of Pragjyotishpur Police Station case number 8/2025. Stop. Considering the period of detention already undergone by the petitioners, progress of the investigation made till date, as well as the fact that some of the articles stolen, which are alleged to be stolen, have been recovered. This court is of considered opinion that if the petitioners cooperate in the investigation, their custodial detention may not be necessary. Stop. In view of above, both the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions. Condition number 1 and 2. With above observation, this bail application is disposed of. Send back the case diary.
They may be directly appear before them.
The petitioners, third paragraph, the petitioners, after their release, shall appear before the investigating officer within 10 days of their release and cooperate in the investigation.
I am deeply obliged.
Withdrawals behind the bar for more than 36 days. So this is actually case of 53(1) of Assam Excise Act. Everything was recovered and seized and produced before the court. And Lordship, I am the registered owner of the transport agency. Neither I am the owner of the truck nor the involved in this case, my lord. Lordship will find the FIR vernacular at case 14.
Page number
14. 1-4.
What was recovered?
205 cartons of beer, Lordship. And driver was arrested. I am not the driver, Lordship. I am staying in the Guwahati office. I am the transport agency owner. And
when you were arrested?
Subsequently, Lordship, after arrest of the driver,
Date.
I was arrested on 4th of February at night.
And who are you?
Lordship, I am the owner, registered owner of the transport agency. I took the truck on hire, Lordship. I am not the registered owner of the truck. I have annexed the registration certificate, that is Lordship will find at page
Yes,
21.
Mr. Das.
Yes,
What is the progress of the investigation?
progress is already
Recovered.
they used to smuggle foreign liquor from Arunachal to Manipur. Manipur is a dry state, and in Arunachal Pradesh, the cheaper wine shop because of free excise duty. So they were doing duty earlier also. They did. This.
So I have no other cases.
Only length of detention, otherwise not, it is, materials are there.
Okay.
He is running the business.
Heard Mr. B. Bhuya,
PK Sharma.
P.K. Sharma, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner Surendra Kumar Pandit, who has been detained behind the bars since 4/2/2025 within bracket for last 36 days in connection with Dokmoka PS case number 6/2025 under section 4 from page number 2A under section both. The gist of accusation in this case is that on 2/2/2025, one Partha Pratim Bhattacharya, SI of police had lodged an FIR before the officer in charge of Dokmoka police station, inter alia, alleging that doing regular Naka checking duty in front of the police station at about 8 a.m. in the morning, one truck bearing registration number AS01 KC6645 coming from Arunachal side and moving to Manipur was intercepted, and on search of the said vehicle, 205 cartons of beer was found there. During interrogation of the driver, it was found that the seized beer was illegally smuggled from Arunachal Pradesh to Manipur. Stop. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR. He submits that the petitioner is the owner of the transport company,
Aryan Logistics.
namely Aryan Logistics, which has hired the vehicle which was seized in connection with this case.
I'm sorry, Aryan Road Lines.
Aryan Road Lines. Stop. He further submits that considering the period of detention undergone by the petitioner, his custodial detention may not be necessary. Hence, he may be allowed to go on bail. On the other hand, learned additional public prosecutor, Mr. D. Das, has produced the case diary of Dokmoka PS case number 6/2025 and has submitted that there are sufficient incriminating materials against the petitioner in the case diary. He, however, submits that the seizure of the smuggled beer has already been made and the investigation has fairly progressed. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the case diary of Dokmoka PS case number 6/2025. Considering the progress in the investigation as well as period of detention already undergone by the petitioner in this case, his further custodial detention may not be necessary if he cooperates with the investigating officer. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate,
Karbi Anglong.
Karbi Anglong, with following conditions, number 1 and 2. Send back the case diary.
I'm deeply okay.
Please, Your Lordship. 45 days on and date, Lordship, 60 days indemnity.
Case that is not received today.
What is the offense?
Offend, Lordship, by making a fake Lordship Instagram ID, Lordship, uploaded some photo of the.
When will you produce the case diary?
Monday,
Today is this.
No,
Monday.
Monday it will be too long, Lordship. 45 days already. There's no direct involvement, Lordship. She have willingly, Lordship, made a photo session, Lordship, photos were clicked and thereafter, Lordship, it was uploaded, Lord. She was paid for the photo session, Lordship.
Thursday and Friday holiday, my lord. That is why.
Thursday, Lordship, kindly, Lord.
Thursday holiday, my lord.
Thursday, no, Friday only.
Thursday holiday.
Theodore Kula আছে। Theodore Kula আছে। Only on 13 Lordship. Otherwise, no direct involvement, Lordship. It was not
What is the allegation?
allegation, Lordship, uploading photo, Lordship.
Obscene photos.
Lordship, but that was clicked by her, Lordship, during a photo session, Lordship. She was paid for that.
Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. R.J. Burma, an additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. When
13, my lord.
let this matter be listed again on 13th.
Much obliged. Much obliged.
May I please, small prayer is here. In the scan copy of the learner's trial code, the report shows only up to 9/9/24. Thereafter, so many days have been passed by, 29/24 to last 7/3/25. There is no report in the scan copy. Kindly be.
No,
called for-
that is not required. You point out what incriminating materials are there against the petitioner.
There is no specific report in this scan copy.
In your complaint petition, it must have been mentioned. Complaint which was filed by DRI. Their case is that they were following the car. And apart from their confessional statement, there is nothing. You point out what else is there. If anything else is there, their bail will be rejected. But if nothing else is there, they may get bail.
May I please, Your Lordship. My lord, the case is charge sheeted, my lord. We have been shown as absconded. We are ready to face the trial, my lord. To that effect, I have given two judgments, one apex court and one high court, my lord, in NDPS and POCSO Act, my lord. And other two judgments are with me also. Of the one is Supreme Court and others the series of judgments of our own Guwahati High Court, my lord.
What is the case?
Case is that the
No,
Why
no.
she was
Case
coming-
is POCSO or NDPS?
POCSO.
Then no.
My
no.
lord, before my learned friend start, my lord, let him satisfy regarding maintainability of
It
this
is not
application.
maintainable.
Not maintainable also.
It is not maintainable because suppose
I
you,
understand.
you
Gang rape.
whatsoever, what may
Here, my lord, kindly come to the affair. my lord.
court has issued any process against you.
Warrant of arrest issued. That's why we have come here. We are ready to face the trial.
You appear before the trial court.
I am ready, but kindly protect us. That has been mandate of this apex court and our own high court.
No, but special court is empowered to grant you bail.
Empower, always empowered. Your lordship is also empowered. my lord.
But this court will not exercise the power if other court is already empowered.
Well, our Supreme Court has accepted this. I have annexed one judgment, other one with me, and our coordinate benches are granting regularly bail. I have annexed one judgment, POCSO case, charge sheeted, warrant of arrest issued. Bail has been directed to go and appear and bail. Bail has been given, protection has been given.
And what is the reasoning?
He is willing to face the trial, and moreover, he has been shown
You
absconded.
satisfy the trial court that you are willing to face the trial.
That's why I'm willing
Uh,
to go to affair. But your lordship, Supreme Court has given observation. Our own High Court also given that the moment I will appear, I will be put into behind the bar. That's why we have come here, madam.
mhm. Which judgment you are relying?
Two judgment I have given, my lord, annexed, my lord. I have annexed, my lord. And another one judgment of this Sanjeev Kumar Bafna from Supreme Court and our own High Court also, my lord.
No, Mr. Vishwas.
Yes.
You citing of many cases may not help you. You point out which case you are relying upon.
My lord, kindly page number 29, Bharat Chaudhary versus
What Bharat Chaudhary says.
that 438 can be applied
Okay, it
in
can
a
be.
charge sheeted case.
Yes.
We do not dispute
Yes,
that
I-
proposition.
That, my lord,
Can be applied in such that case, my lord. But before that, my lord, let him satisfy 480 to 4, my lord. BNSS.
then besides that, my lord, there is
Okay.
another case, my lord. I have given.
480 to 4, let him satisfy first, my lord.
Okay.
Let him overcome that, my lord.
There is a statutory bar. Mr. Vishwas,
Another judgment I have given, my lord. Yes.
there is a statutory bar 482(4). In case of gang rape, the anticipatory bail.
Any other day, my lord, I will
Hmm.
satisfy. Let me find out any judgment, whether court can get it.
Okay. Heard Mr. S.C. Vishwas, learned counsel for the petition. Also heard Mr. R.J. Barua, learned additional public prosecutor, as well as Mr. K.
Mira,
K. Mira,
for respondent number 2.
for respondent number 2. Learned additional public prosecutor has pointed out that this anticipatory bail application is barred by statute. That is, he submits that as the offense of gang rape is involved in this case, by operation of section 482 clause 4 of the BNSS, the application for anticipatory bail is barred. Stop. On this, learned additional public prosecutor, on this, Mr. S.C. Vishwas, learned counsel for the petitioner, seeks leave of this court, makes a submission that he may be granted some more time to find out some authority which would show that his anticipatory bail application is maintainable.
Yes, ma'am.
The prayer is allowed. Let this matter be listed again on.
He did it after 2 weeks, madam. 10 days after.
Give a fixed date. Again on
On 20th, madam.
20th of March,
20.
20.
20 March.
Maybe little more.
Yes, that is there.
My lord, case diary not received, my lord. Probably, my lord, the same issue, my lord.
Same issue.
Same issue, my lord. 480 to 4, my lord. There is a bar.
It is barred.
Another date may be fixed, I will submit the judgment.
Okay. Heard Mr. M. Hawk, learned
Charge it, my
learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor, as well as Ms. M.K. Brown, learned counsel for respondent number 2. Learned counsel for the learned additional public prosecutor points out that this anticipatory bail is barred by section 482 within bracket 4 of the BNSS. So upon this, learned counsel for the petitioner prays for some more time to find out and appropriate authority to impress upon this court that the instant anticipatory bail application is maintainable. The prayer is allowed. Let this matter be listed again on 10th of March 2020.
My lord, we have received the case diary just now, my lord. That may be mentioned, my lord.
The
Collected, my lord.
case diary will be retained.
But till 10th of March, we retain, my lord.
The
10th of March.
today is 10th of March,
I am sorry, my lord. Lordship is fixing on 20, my lord.
20th of March,
20th.
20th of March. The case diary which is available before the court shall be retained till the next date fixed. Official NDPS case. Court number 3.
Like criminal petition.
Go through the roster properly. There are 2 senior courts.
Right.
You have to mention before the senior court.
Well, it is a criminal petition.
Court number 11.
Well, it is not taking NDPS. And
Criminal petition will go to court number 11.
that is true, but your lordship, that bench not.
You mention before that bench.
I'm in impression, my lord, NDPS and criminal.
Have you mentioned?
No, ma'am.
Mention it before that.
Wait, please, your lordship. Lordship, I may allow to withdraw because a charge sheet has been submitted.
Heard Mr. B. Chaudhary, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw this instant bail application on the ground that charge sheet has already been laid. The prayer is allowed. This bail application is dismissed on withdrawal.
Highly obliged.
I think I am number 4.
Wait, please, your lordship.
Yes.
This is a regular bail application, lordship. In this case, this petitioner today in jail custody for 228 days, lordship. Now, lordship, my submission is that, lordship, the charge sheet was not filed within time, within the statutory period, lordship. So my indivisible right has been curtailed, and that was denied by the court below.
This you have mentioned in the morning. No, that
Morning, lordship, I don't know.
he has completed 180 days.
Yes, lordship. He has completed 180 days, lordship. May I take you, lordship, the FR that is on page 15, lordship?
Yes. Oh,
My lord, charge sheet file. My lord, investigation completed, my lord, and charge sheet, my lord, ready on 11/1/2025, my lord.
11/1/20.
So 11/1/2025, my lord.
Date of charge sheet.
Date of charge sheet, my lord. On this day, my lord, it was 177 days, my lord.
Yes, but the
Now, my lord, let me complete, my lord.
yes.
Now, my lord, on 14/1/2025, my lord, he has completed, my lord, 180 days, my lord.
14/1/25.
2025, my lord.
Okay.
Now, my lord, I rely on one Supreme Court, my lord, ruling, my lord, 1994 4 SCC 602, my lord.
1994.
4 SCC 602, my lord.
What it says?
My lord, he said, my lord, if the right accrues to the accused person, my lord, for the indefeasible right, my lord, then, my lord, if he has not, my lord, filed any application, my lord, then he cannot claim, my lord, later on, my lord. Now, my lord, 14/1/2025, it is 180 days, my lord. That means, my lord, on 15/1/2025, my lord, he ought to have filed the bail application, my lord.
When he filed in this case?
He filed the bail application on 16/1/2025, my lord.
Where is that judgment?
That, but the soft copy I'm not having, my lord. I'm only having the citation, my lord. Paragraph 48, my lord.
It will look 1994 4 SCC. 1994 4 SCC 602. Do you have the name of the parties?
Yes, my lord. Hitendra Vishnu Thakur by the state of Maharashtra.
Okay.
May I allow the signature?
Just a minute, Mr. Chand. So
So,
he
my lord-
should have filed the application on 14th,
On 15, my lord, because on 14, my lord, 180 days,
on
my lord.
15, he filed it on 16th.
He filed it on 16, my lord.
And the trial court rejected that prayer on the ground that
The searches, my lord, search, on that day, itself, my lord, trial court, my lord, received the search sheet, my lord. That is, my lord, what he has, my lord. That order here is already annexed, my lord. That is in page number, my lord, 35 onwards, my lord.
okay.
My humble submission, my lord, let the scan copy be called for, my lord.
No, we will decide it. If,
My lord,
if
yes,
this
my
is the,
worship can decide, but this is the
if-
facts, my lord.
if this is the only issue to be decided,
Yes, my lord.
you are relying on no, which judgment?
Me, Lordship.
Yes, Mr.
This is
Chand.
the latest judgment, Lordship. 2024, Lordship, Volume 7. Supreme
Citation
Court
is
140.
citation.
147. Lordship, I have the citation, Lordship. No.
What it says. Which para?
Paragraph 61 and 62, Lordship.
Yes, what it says.
May I read, Lordship, that paragraph?
Yes.
Since there exists vacuum in the application and detail of the section 167 CRPC, we have opted for an interpretation which advance the cause of personal liberty. The accused herein were remanded on 14/5/2020. As such, the charge sheet ought to have been filed on 12/7/2020. That is on 60th day. But the same was filed on 13/7/2020, which was 61 day of their custody. Therefore, the right of the default were accrued to the accused petitioner on 13/7/2020 at 12 a.m. midnight. That his right accrued from the midnight of that 13/7/2020, Lordship. Here in my case, Lordship, he was arrested, Lordship, on 19/7, Lordship. Then on produce on, Lordship, 27, Lordship. There, that is, Lordship, on July month, Lordship. He was in jail custody for 12 days. August 31, September 30, October 31. Then, Lordship, November 30.
No, don't go in this way.
Because that
Yeah.
way, Lordship, my statutory period is over on 15th, Lordship.
15th of
15th of January, Lordship. Statutory period over on 15th of January, Lordship.
it would have. You
My lord, that, my lord, the paragraph is not similar, my lord. Because I am referring to my Supreme SCC judgment, my lord.
no, give it to him. You
My lord,
find
that I
out
have
the
to find out, yes,
find
I
out
have
the
to find out.
paragraph. According to you, the statutory period was got over on 15th of January,
Yes, Lordship.
and you filed bail application
On 16th, Lordship. Because my indefeasible right started from the 15 midnight, Lordship. And they have, Lordship, placed the charge sheet on, Lordship. It has been seen on 16/1, Lordship.
Okay. Then record may be necessary.
My lord,
When the charge sheet was
charge sheet received by the office, my lord, as per the my lord order, my lord, what order has reflected, my lord. It is received in the office on 16th of January. my lord.
when?
That is, Lordship may kindly come to my lord. Page number 37, my lord, of the bail application, my lord.
In the bail application itself, it is reflected.
Yeah. From 37, my lord, 37 onwards, my lord, last two line, my lord. In the instant case, it is found that charge sheet has been filed and seen by this court on 16/1/2025, and record shows that the bail application was received subsequent to receipt of the charge sheet by the court seeking default bail. Hence, as charge sheet is already seen by the court and accused failed to file the bail application seeking default bail when the right accrued, I do not find merit in the instant petition seeking default bail as charge sheet is already filed and seen by the court, and accordingly same is rejected.
What has been observed in Hitendra Vishnu Thakur, that bail application has to be filed
My lord, assuming my lord in this
before
case,
filing of charge sheet.
before filing of the, suppose assuming my lord in the instant case, my lord, his my lord 180 days completed on 14/1/2025. So till 14/1/2025, my lord, he may file it, my lord, but he cannot press, my lord. But on 15/1/2025, my lord, he will have to file it. If the charge sheet is not filed at that time, my lord. If he has not filed, my lord, then his indefensible right would have been extinguished. my
In
lord.
the instant case, he has filed on 16th.
16, my lord.
Charge sheet is also filed on 16th.
Charge sheet is also placed before the court on 16, my lord.
So it is the time when the
Yes.
charge sheet is placed before the court that has to be
That is, my
taken.
lord, as part of my lord, our judgment of
Yes,
our.
So
right,
on
my-
16th, charge sheet was also filed and bail application was also filed.
Was also filed, my lord. But my lord, as part of rejection order, my lord, bail application was filed, my lord, subsequent to the filing of. the
Filing of charge sheet.
my lord.
Okay, then to you
my
don't.
Then, my lord, another judgment, my lord, that 2023 Live Law Supreme Court 249, my lord. 2023 Live Law Supreme Court 249. My lord, Enforcement Directorate versus Kopil Wadhwa and another, my lord.
That I have placed.
In that case, my lord, from the date of arrest, my lord, his, my lord, judicial custody has to be calculated, my lord. Earlier, my lord, in my lord, Ravi Prakash case, my lord, the date, from the date of forwarding, my lord, the date of custody has to be calculated, my lord. But that has been overruled, my lord, and it is said, my lord, from the date of arrest, my lord, my lord, judicial custody has to be calculated, my lord.
From the date of production loss. It is reflected in para 62 loss. Para 61 and 62 loss covered my case loss.
61 and 62 of
Of lordship enforcement director versus Kapil Wadhwan loss. This my learned friend I have placed loss. I have placed that judgment.
Mr. Borwa, according to you, the 180 days completes on
14/1, my lord.
and Mr. Chaudhary,
It is completed on 15/1 lordship.
That the lordship can also, my lord, calculate from the.
That's
date
why
of-
lordship I am giving the date lordship exact date.
I have also calculated, my lord.
Yes.
okay. Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Mabrur Ahmad Chaudhary, who has been detained behind the bars since 19/7/2024 in connection with Karimganj PS case number 462/2024 under section 22C/25/29 of the NDPS Act, 1985, corresponding to special case. What is the special case number? After filing of the charge sheet,
Special NDPS case number 81/24, Lordship. Case-
corresponding to special NDPS case number 81/2024, pending before the Court of Learned,
Special Judge Sri Bhumi.
Special Judge Sri Bhumi. Stop. The gist of accusation in this case is that on 27/2024, one Jyotish Kumar Nandi had lodged an FIR. No. On 19/7/2024, one M. Ngathoiba, Nganthoiba, Ngathoiba Singh had lodged an FIR before the officer in charge of Karimganj Police Station, inter alia, alleging that on receipt of an information through reliable sources regarding storage of large quantity of prohibited drugs by the present petitioner, regarding concealing of large quantity of narcotic drugs by the present petitioner in one Hero Glamour vehicle bearing registration number AS 110A6892, a police team was constituted and a search operation was conducted. During search operation, how much contraband? 700 and
6,600, Lordship. Yoba tablet, Lordship, found. The quantity is
6,600 numbers of Yaba tablet containing methamphetamine, weighing about 766 gram in total, were recovered from the possession of the present petitioner. Stop. Learned counsel for the petitioner has submitted that the petitioner has approached the Court of Learned Special Judge Sri Bhumi for bail, for default bail, on the ground that even after detention for a period of 180 days, the charge sheet was not laid, and therefore the petitioner is entitled to get default bail under section 167 of the CRP, 167 within bracket 2 of the CRPC. However, by order dated 21/2024, the prayer for default bail was rejected by the Special Judge Sri Bhumi. Learned counsel for the petitioner has submitted that the petitioner was arrested on
19/7, produced on 27. 2024
19/7/2020
is the date of arrest and production. Lordship, on
2024
24
or
Lordship, 24 Lordship.
24?
Production produced on 27/2024.
24, and he was produced before the court on 27/2024 and was remanded to custody on the same day, said date. Learned counsel for the petitioner has submitted that if the date of remand is taken into consideration for computation of 180 days of detention of the petitioner, the period of 180 days was completed on
15 January 2025.
15 January 2025. Learned counsel for the petitioner has submitted that on 15 January 2025, the charge sheet was not placed before before that. Learned counsel for the petitioner has submitted that though in the charge sheet which was submitted in this case, the date of charge sheet has been mentioned as 11 January 2024. However,
25 Lordship.
2025, however, this said charge sheet was not placed before the special judge Sri Bhumi till 16/1/2025. Learned counsel for the petitioner has further submitted that due to failure on the part of the investigating officer to place the charge sheet before the special judge court on completion of 180 days of detention of the present petitioner, the right to default bail of the petitioner accrued on 15th of January 2025 at about midnight onwards. Learned counsel for the petitioner submits that on the next day, on the next day, that is on 16th of January, the petitioner approached the court of learned special judge Sri Bhumi seeking default bail. However, his prayer for bail was rejected on the ground that on the said date itself, that is 16th of January 2025, the charge sheet was laid before the trial court. Stop. Learned counsel for the petitioner has relied on the ruling of Apex Court in the case of Enforcement Directorate, Government of India versus Kapil Wadhawan and another, reported in 2024, 7 SCC 147, wherein it was observed as follows, Court Para 6162 from the said judgment. The learned counsel for the petitioner has also, where is Noor? Samsul Noor.
Samsul Noor Marot, I have got the only Marot the bail application number.
You are relying on Samsul Noor?
No.
No.
Lordship, relying on this judgment, Lordship, because it's covered my case, Lordship.
But
That was old one, Lordship. It is the recent one, Lordship. It's a 2024 judgment, 7th of Supreme Court. And that my learned friend referred probably it's
No,
Samsul
Samsul
Noor-
Noor helps you also.
Yes.
Unless,
Samsul Noor helps
without
him, my lord.
Samsul Noor, he will not get benefit.
My lord.
Because
Bail
lordship-
application number 1958.
Samsung, that one, lordship, our High Court order, lordship.
So
that
what
is-
I am saying,
Yes, 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 I forgot that.
learned counsel for the petitioner has also cited a judgment of coordinate bench of this court in the case of Samsul Noor, alias Samsul Noor versus State of Assam, within bracket bail application number 1958 102022 slash 2022 dated 7/10/2022, wherein
Para 38, lordship.
it was observed that as follows. Quote paragraph number 38 from the said judgment. On the other hand, learned additional public prosecutor has opposed the grant of bail to the present petitioner on the ground that the quantity of contraband seized in this case is of commercial quantity, and therefore embargo of section 37 of the NDPS Act is applicable to this case. He also submits that the petitioner is also not entitled to default bail as the default for availing the benefit of default bail, the petitioner shall have to file the bail application as soon as the right of default bail accrues, but before filing of the charge sheet. However, he submits that in the instant case, the petitioner failed to file. He also submits that in the instant case, 180 days of detention of the present petitioner was complete on 14th of January 2025.
No, my lord, that
15th
14th of
of
January, he has completed 180 days, my lord.
yes,
And my lord, on 15th of January, my lord, his right accrues, my lord.
14th of January 2025, and his right to file default bail accrued on 15th of January. However, in the instant case, he submits that the petitioner filed the bail application on 16th of January. And before his filing of the bail application, the charge sheet was already placed before the learned special judge. And therefore, he submits that the petitioner is not entitled to get default bail in this case. I have considered the submissions made by learned counsel for the. Where is that judgment, Mr. Borwa?
I'll place the, my lord, I'll bring and place the, my lord, the accessory on accessory citation, my lord.
Okay,
Because I'm not be able to find out, my lord. The paras are different, my lord.
okay. Learned counsel for the petitioner has no, before that, learned additional public prosecutor has also relied on the ruling of apex court in the case of
Well, Hitendra Vishnu Thakur, my lord,
Hitendra Vishnu Thakur
versus State of Maharashtra,
versus State of Maharashtra, reported in
1994, 4 SCC 602.
1994 4 SCC 602. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record. When will you?
That's after some time, my lord.
Okay. Then I will dictate the remaining part after going through that judgment. Today itself, I will dispose it off.
Obliged.
Okay, Lordship. My lord, apparently there is some mistakes, Lordship. My lord, I may be allowed to file amended procedural and the case may be converted.
You withdraw it and file a fresh. The,
Liberty may be given.
yes, take that liberty. Heard Mr. M.I. Hussain, learned counsel for the petitioner who prays for allowing the petitioner to withdraw the instant criminal revision petition due to certain mistake which has crept in the petition with liberty to file appropriate application. Stop. The prayer is allowed. This case is dismissed on withdrawal with the liberty sought for is with the liberty as sought for granted. Yes, this is, okay, I have gone through it. We are disposing it off. इसका अभिषेक आधा डिक्टेशन हो गया है. Okay, take dictation. The records of criminal जितो call करा this court has requisitioned the records of criminal petition number 1131/2023 to verify as to whether the said criminal petition is still pending or not. On perusal of the records, it appears that by order dated 16/10/2023, the 16/10/2023 passed in criminal petition number 1131/2023 the further proceedings of complaint case 2023 complaint case number 23/2022 under section 138 NI Act pending before the Court of Learned Judicial Magistrate First Class Dhubri was stayed by this court. There is no order by this court modifying the stay order, modifying the said stay order. Under such circumstances, the impugn order dated 16/10/20, no, impugn order dated 19/12/2025, 2024, passed in CR case number 23/2022 by the Learned Judicial Magistrate First Class appears to be a clear violation of the orders passed by this court. Before proceeding with, it is pertinent to mention herein that before proceeding with the trial of the said court, the Learned Judicial Magistrate ought to have verified from the registry of this court regarding the pendency of the criminal petition number 1131, pendency or otherwise of criminal petition number 1131/2023. And only after verifying that the stay order passed by this court has verifying that as to whether the stay order passed by this court is vacated or not, the learned magistrate ought to have proceeded with the trial of the CR case number 23/2022. Stop. As already observed that the impugn order is in violation of the order passed by this court, the said order is hereby set aside. And the further proceeding of CR case number 23/2022 shall remain stayed in pursuant to the order dated 16/10/2023 passed by the coordinate bench of this court in criminal petition number 1131/2023. This criminal petition is accordingly disposed of without issuing notice to the others.
Deeply.
Okay, member. Indicate for- I got the dictation level. Yes.
May I please, your lordship? FIR at phase 14, my lord. Charge sheeted, madam, my lord.
Yeah, whether victim has been examined.
No, my lord. Yet not examined, my lord. But for evidence, my lord, 4 dates have been fixed, my lord. But till date, my lord, not a single witness stand up, my lord.
Where is the FIR? Let us
FIR phase 14, my lord.
page 14.
14, my lord. My type copy, my lord. May I read, my lord?
Yes.
Most respectfully begs to state that the above mentioned accused person is a driver. He is staying in my house for about last 7 days, and I used to call the accused person as maternal uncle. In such situation, on last dated 1/8/2024, in the night at around 8 o'clock, upon getting information from my father's home, I left my 2 minor daughters at my home with the accused person, and I went to my father's home.
When
with
the
my
charge sheet was filed?
My lord, charge sheet at page, my lord, 21, my lord.
When it was filed?
31/8.
31/8, my lord.
Yes, Mr. Burra.
My humble is that the victim examined man.
Yes, Mr. Ahmed.
Last two, court also lordship directed, posted this matter today because the last date of examination of witness was 6 lordship, as per their submission, 6 of March. lordship.
What happened on 6th of March?
I have no instructions.
My lord, I have
Not examined.
on 6 also no witness stand up, my lord. The next date is now fixed on 26th of May, my lord. And the accused is in custody, my lord. As on date, my lord, 221 days, my lord. And charge sheet is under, my lord, section 75 of BNS and section 10 of POCSO, my lord.
Sexual assault.
Sexual assault, my lord.
Lordship made 5.
Or there is
It
not.
was the 183 statement. Man.
Yes.
Cannot be said also whether it's a sexual assault. Man.
My lord, if we go through to the charge sheet, my lord, statement of the victim, also there, my lord. At page 25, my lord.
The victim was also, my lord, not medically examined, my lord.
No, but let the victim be examined. One,
My lord, as on date, my lord, 221 days, my lord, he is in custody. He will, my lord, abide by any condition, my lord, any condition, my lord. 4 dates, my lord, has been left, my
No.
lord.
heard Mr. What should we do, Mr. Borua? Should we dispose it off?
I leave it to Lordship.
We are dismissing the petition now. You approach the trial court after examination of the victim girl. We are issuing directions.
My lord, but,
Heard Mr. What is your name?
my lord, then date may be fixed.
What is your name?
Here, Rashid, my
A. Rashid, learned counsel for the petitioner. Also at Mr. R.J. Borua, learned additional public prosecutor, as well as Mr. A.K. Azad, sorry, A.Z. Ahmad, learned counsel for the respondent number 2. This application under section 483 of BNSS has been filed by the petitioner, namely Jamir Ali, who has been detained behind the bars since 2/8/2024 in connection with special POCSO case number 174/2024 pending before the Court of London. Special Judge South Salmara, Bankachar. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars since 1/8/2024 and not even a single witness has been examined. He submits that the petitioner is ready to cooperate in the trial. On the other hand, learned additional public prosecutor as well as Mr. A.Z. Ahmed, learned counsel for the petitioner, submits that considering the fact that the victim in this case is a minor girl, the prayer for bail may be considered only after examination of the victim girl. So, learned counsel for the petitioner has submitted that next date of this case, next date of the special POCSO case is fixed before the
26
trial
of-
court on
26/5,
26/5/2024.
25.
2025. Stop. This court, after considering the materials available on record, is of considered opinion that the prayer for bail may be considered only after examination of the victim girl. Stop. The trial court is directed to make all endeavors to examine the victim girl on the next date fixed. Place this matter in the last week of May on a date to be fixed by register. No, list this matter again on 29th of May. None has appeared.
34 started submission.
Charge sheet submitted. You are on interim.
Yes, my interim.
You have appeared before the investigating officer. Yes or no? You are not confident. You are not confident while answering. Is it yes?
Yes.
Okay. Heard Miss S. L. Sarkar, learned counsel for the petitioner, also heard Mr. R.J. Borwa, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by this court by order dated 20/1/2025, and in pursuant to the directions of this court, the petitioner Anisul Islam has cooperated with the investigating officer. Stop. On the other hand, learned additional public prosecutor has submitted that in the meanwhile, charge sheet has already been laid, bearing charge sheet number
59/2024, dated 31/12/2024.
Considering the submissions made by learned counsel for the petitioner, as well as the fact that the charge sheet has already been laid, the interim anticipatory bail granted to the petitioner by order dated 20/1/2025 is hereby made absolute, with condition number 1, 2, and 3 attached to the said order remaining intact. With above observation, this anticipatory bail application is disposed of.
Map lesion. Case diary not the same. Case diary.
Heard, Mr.
Interim may be allowed or not.
You are already on interim.
Case diary has not been.
What is your name?
AM Siddiqui, your lordship.
Heard, Mr. A.M. Siddiq, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed again on
28/3, man.
28/3. The interim order shall continue till next date.
As per the office note, CD has not been.
Hello, we have received a report from the concerned investigating officer, my lord. And from the report, my lord, there is no apprehension of this arrest of this person. My lord.
Okay, why? What is your case?
Actually, lordship, I am not the affair name accused. I am the family member of the affair name accused person.
They will not arrest him.
Police is not my lord.
Then we'll make it absolute. If they
It's
arrest,
not required, my lord, since there is no apprehension, my lord. When the apprehension will come, then also, my lord, some protection will be required, my lord.
An interim is there, your lordship.
no. But police is saying that they will not arrest.
But they are harassing me.
Harassing and my lord, person is arrest, searching for arrest is different, my lord.
Heard, Mr. M. Ali, learned counsel for the petitioner. Also heard Mr.
A.
R.J. What is your name?
A Islam.
Heard Mr. A. Islam, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor. The petitioner was granted interim anticipatory bail. Have you appeared before the IO?
Yes.
Petitioner was granted interim anticipatory bail by this court by order dated 20/2/2025 and with certain conditions. Stop. It is submitted by learned counsel for the petitioner that in pursuant to the directions of this court, the petitioner appeared before the investigating officer of the Sapatgram PS case number 6/2025. On the other hand, learned additional public prosecutor has produced a report furnished to him by the investigating officer of Sapatgram PS case number 6/25, namely Shri Orchid O.K. Soikia, SI of Police, who has categorically stated in his report that the accusation is against the main accused, Mufazzal Haq, and the petitioner, namely Akhtarul Alam, is not required to be arrested in connection with the Sapatgram PS case number 6/2025. In view of the report of the investigating officer, it appears that there is no apprehension of getting arrested. There is no apprehension of the petitioner getting arrested in connection with Sapatgram PS case number 6/2025. Accordingly, this anticipatory bail application is disposed of. Record of
Wait, please, your lordship. Here, my lord, I'm on interim, my lord. I appeared, my lord. I've cooperated, my lord.
Yes, CD is there.
Yes, case they received, my lord.
He has appeared.
Yes, he has appeared, my lord. Statement.
Heard Mr. S.M. Abdullah P, learned counsel for the petitioner. And also heard Mr. R.J. Burwal, learned additional public prosecutor. This application under section. No, for the learned counsel for the petitioner has submitted that by order dated 24/2/2025, the petitioner was granted interim anticipatory bail by this court, and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. Stop. Learned additional public prosecutor has produced the case diary of Rauta PS case number 134/2024 and has submitted that the petitioner has appeared before the investigating officer and his statement under section 180 of BNS has also been recorded. In view of the fact that the petitioner has cooperated with the investigating officer, the interim anticipatory bail granted to him by order dated 24/2/2025 by this court is hereby made absolute, subject to the condition that he shall continue to cooperate in the investigation.
Yes, sir.
Obliged, my lord.
Lordship, on the last occasion, lordship, the query was that lordship, the PC is to submit whether 29 was added or not, lordship. We also checked the record, lordship, in lower court, 29 is not added, lordship.
Lower court record.
Lower court, if the original record, that check for all.
Lordship, I took the instruction, lordship, but as per the instruction of the IO lordship, 29 is not added, lordship.
Then
Then Lordship, my earlier submission will stand as it is Lordship, because Lordship, the order Lordship I have submitted before you Lordship. That is the state of Haryana versus Samrat Kumar Lordship. In that case, Lordship, that case is also not added with the section 29 Lordship, even though that bail has been rejected Lordship. And my humble submission before you Lordship is that Lordship, non-adding of section 29 at the investigation stage Lordship, that may not be a ground for getting anticipatory bail. Whereas Honorable Apex Court has repeatedly saying, observed that Lordship, giving anticipatory bail in NDPS case is a very serious issue Lordship. And if it is, yes, if it is a, if the bail application has been filed after submission of the charge sheet, then there may be a ground Lordship that even though Honorable Court may add Lordship, but there may be a ground that 29 without adding 29 and that charge sheet has been filed Lordship. But it is now, it is in investigation stage. CD is lying with the office of the PP since long time Lordship, and no, because of non-submission of that section Lordship, that may not, that interim protection may not be granted Lordship. That is my humble submission before Lordship. Because Lordship, that order earlier I have submitted before Lordship, it is under section 17, 27A and 85 of NDPS Act. Lordship.
Where is that order?
Lordship, I have submitted, is it?
Okay, okay.
Lordship.
No, it is there.
Lordship.
Samrat.
That is Samrat Kumar Lordship. That the para 2 Lordship, first leave granted to both the appeals arising out of independent orders passed by Honorable High Court, High Court of Punjab and Haryana at Chandigarh, granting pre-arrest bail to the respondent herein who are implicated for alleging offences under section 17, 27A and 85 of NDPS Act Lordship. And this is also for regarding co-accused of the petitioner, because para 4 stated Lordship. The High Court decided to grant pre-arrest bail to the respondent on the only ground that no recovery was.
Why are you apprehending your arrest?
Because police is looking for me Lordship, charging me Lordship, and that has been revealed that by the FR itself says Lordship. Stated Lordship, and the recovery was 12 gram Lordship, 12 gram from his possession. My house was also charged Lordship, nothing was found. Immediately after the statement of the court, my house was searched and nothing was found.
No, but in this case which you have cited is a different case. 27A is there.
27A is there, but 27A.
Here, apart from possessory offense, there is no other.
But regarding 27A Lordship, there is a separate punishment is there Lordship in 27A, but in 29 there is no separate punishment is there Lordship. So Lordship, my humble submission, 27A is a separate section Lordship. It can be added, but along with that Lordship, 29 will automatically come Lordship. Because 29.
But in this case, there is no 29.
29 Lordship.
29 should be immediately.
So if you add 29.
Lordship. It is the time, it is not that the IO has submitted a charge sheet Lordship.
No, it should have been added in very fast day Lordship, because the co-accused was charged on because of his statement, Lordship, co-accused statement, so immediately it has been Lordship.
Where is the statement? What is the statement against him?
It is clearly in the FIR itself.
FIR itself
it has been on the page 10 Lordship, the last paragraph. On interrogation at the spot, he stated that he is dealing in drug business for long days. Today he purchased the recovery drugs from one Raja Ali. This is the.
You are Raja Ali.
I am Raja Ali. Yeah, it specifically mentioned today Lordship. Today he purchased Lordship the recovery.
Then you will not get bail. Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. P.S. Laka, an additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Raja Ali, who is apprehending his arrest in connection with volume of PS case number 1/2025 under section 21B/21B of the NDPS Act 1985. the gist of accusation in this case is that on 12/2/1/2025, one Pradyumna Kolita, SI of police had lodged an FIR before the officer in charge of Horolumuk police station, inter alia, alleging that on receipt of an information that some person would be selling drugs in Bhutnath Kalipur area, a search operation was conducted. And during search, one Jahidul Islam was apprehended, from whose possession 10 numbers of plastic vials containing heroin were recovered. In the total weight of heroin which was recovered was 12 grams. During interrogation, the apprehended person revealed that he purchased the said heroin from the present petitioner. Learned counsel for the petitioner has submitted that the petitioner is an innocent person, not involved in the offense alleged in the case. He submits that apart from the statement of the co-accused, which is not admissible in evidence in a case involving NDPS case, there is no other material against the accused, against the petitioner. He further submits that what is your other submission?
That it was functioning with fraud, Lordship.
He further submits that the police is searching for him, therefore he is apprehending his arrest in connection with this case. On the other hand, he further submits that the case has been registered under section 22B only, and there is no accusation of offense under section 29 in this case. On the other hand, learned additional public prosecutor, Mr. P.S. Locker, has vehemently opposed the grant of bail to the petitioner on the ground that the case is still at investigation stage, and during investigation stage, if sufficient materials are found, relevant penal provisions may be added at any time. He also submits that though the incriminating materials against the present petitioner at this stage is the statement of the co-accused who was apprehended in this case and from whose possession the contraband was recovered. However, at this stage of investigation, on the basis of however, he submits that the advantage of the decision of Tufan Singh versus State of Tamil Nadu, reported in
2021 4 SCC page 1.
2021 4 SCC page 1 may not be granted to the petitioner while approaching before this court seeking anticipatory bail.
Apart from that, he is also is a habitual offender. Another same nature of offences he has already been involved in. This.
He further submits that the petitioner is a habitual offender involving NDPS case. Where is the case?
Against him, volume PS case number 155/24 is registered.
And
He is not convicted, Lordship.
he is not.
Bhodolomukh PS case number
155/24 under section
24.
21B 29 NDPS Act.
Is also registered under section 21B. Bhodolomukh PS case number, what was?
155/24.
Under section 21B is also pending against the petitioner. Stop. Learned additional public prosecutor has, in support of his submissions, cited a ruling of the apex court in the case of State of Haryana versus Samrat Kumar, within bracket, order dated 20 July 2022. In criminal appeal number 1006/2022, arising out of SLP criminal number 6683/2023, wherein the apex court has observed as follows.
Right.
Within inverted comma, in the cases of this nature, the respondent may be able to take advantage of the decision of Tufan Singh versus State of Tamil Nadu Supra, perhaps at the time of arguing the regular bail application or at the time of filing final hearing after conclusion of trial. Next para, next within inverted commas. To grant anticipatory bail in the case of this nature is not really warranted. Therefore, we are of the view that High Court fell into an error of granting anticipatory bail to the respondent. Stop. I have considered the submissions made by learned counsel for both the sides. In this case, the apprehended accused has implicated the petitioner to the extent that the contraband which was recovered in this case was supplied to him by the present petitioner. As the investigation is still on, this court is of considered opinion that in view of the observations made by the apex court in the case of State of Haryana versus Samrat Kumar Supra, the benefit of the ruling of Tufan Singh versus State of Tamil Nadu may not be availed by the petitioner in an application for anticipatory bail. Moreover, as submitted by learned additional public prosecutor, the petitioner has been involved in other cases involving offense under NDPS Act. Hence, this court is of considered opinion that this is not a fit case where a favorable order under section 482 of BNSS may be issued in favor of the petitioner. This anticipatory bail application is therefore rejected.
Much obliged, Your Lordship. Much obliged.
What is the error?
Your Lordship, at paragraph 25 precisely, page number 13. In view of the above, the petitioner, namely so-and-so, is allowed to go on bail of rupees 1 lakh, but in words it has been shown as 2 lakh.
Oh. Oh, yes. So that two should be made one. Heard Mr. S. Datta, learned counsel for the petitioner. This interlocutory application has been filed by the petitioner seeking rectification of a typographical error which has crept in the order dated 22/2025 passed by this court in bail application number 126/2025. It appears that though the petitioner Amresh Kumar what is his full name?
Ray.
Amresh Kumar Ray was allowed to go on bail of rupees 1 lakh. However, in the order of granting bail, in paragraph number 25, at line number 2, the figure within bracket, the amount of the bail is wrongly mentioned as 2 lakh in words. Stop. Same needs to be rectified, as same appears to be inadvertent typographical mistake. Stop. Accordingly, this interlocutory application is allowed. The words 2 lakh appearing in line number 2 of paragraph number 25 of the order dated 20/2025 passed in bail application number 126/2025 shall be read as 1 lakh.
Obliged.
With above observation, this interlocutory application is disposed of.
In item 41, there was a direction to take instruction whether notice has been served or not received. I took the instruction received, but though we have sent the notice on 29/5/24. It was sent long back, Lordship, but they are unable to trace out whether it is served or not, police, Lordship. So
you, what to do?
A
A fresh notice
if
has to.
notice can be sent, I will try to serve it.
You have a
through the
copy of
process.
notice.
Lordship, or else, an amicus curiae may be appointed, Lordship. It was long back. As it is a POCSO.
No, but notice has to go first.
Notice has gone, Lordship. Notice has gone, Lordship.
Notice has to be served,
That
and
has-
therefore only amicus may be appointed. The victim may engage in her own.
Sometimes will notice goes, but sometimes they did not receive or avoid the notice.
No, this time there is a report.
We have taken it's just third
No.
time probably.
Please take fresh steps once again.
Well,
Lordship, they may take first step, Lordship, in a short date may be given. So in the meantime, if any instruction comes from them, then this will serve.
Heard Mr. A. Rashid. Heard Miss T. Begum, learned counsel for the applicant. Also heard Mr. Peel S. Locker, learned additional public prosecutor, who submits that though the notice to respondent number 2 was sent to the officer in charge of jurisdictional police station from the office of the public prosecutor. However, it is reported by the officer in charge of the which police station?
Borpeta, Lordship.
Borpeta Road Police Station, that the said notice is not traceable. Stop. In view of the above, facts, the petitioner is directed to take fresh steps for issuance of notice upon respondent number 2 as per the notification prevailing, as per the prevailing notification in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on 4th of April. 4th of April is of
Yes.
list accordingly.
Wait, please, guys. My lord, appeal against acquittal, my lord. And for that, my lord, one criminal leave petition has been filed, my lord.
Heard Mr. P. J. Soikya, learned counsel for the petitioner. Also heard Mr. P. S. Locker, learned additional public prosecutor. This application under section 419 within bracket 4 of BNSS has been filed by the petitioner Halina Khanum, seeking leave to file an appeal against the order of acquittal of the respondent number 2, 3, 4, and 5 by judgment and order dated 9/1/2025 passed in PRC case number 980/2019 by the Court of Learned Additional Chief Judicial Magistrate Morigaon. Issue notice to the respondents. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2, 3, 4, and 5 are concerned, the petitioner shall take steps for issuance of notice upon the said respondents by registered post with ID as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Obliged.
May I please? My lord, the order passed by Honorable Trial Court and the Appellate Court may be stayed. Order and judgment passed by.
Today, I think also this case has been listed for
Order.
service of notice, Lordship.
Service of notice.
Whether it is served or not, Lordship. Service communication. Complaint case, Lordship. NI case, Lordship. So service of notice is required, Lordship.
What is your ground for filing revision?
My lord, the grounds are that check was not issued to the complainant. And next ground was that there is no legally enforceable debt. And there is also ground that demand notice was not received. There is no postal receipt against the said demand receipt. Demand notice.
Now, where are you? Outside?
Yes,
You are not on bail.
yes, in bail.
You are on bail.
Yes.
Till when?
till
কেতিয়ালৈকে আপোনাৰ বেলেগ থাকিব আগৰ অলপ টাইম আছে অৰ্ডাৰ আছে মানে
You pay 20% of the fine amount.
yes, we had
In the
paid.
appeal, you have filed.
Yes, yes.
Again, for filing this revision, you pay again. Are you ready to pay?
My lord, I will have to take instruction.
Okay, take instructions. Heard Mr. C.S. Roy, learned counsel for the petitioner. Also heard Mr. P.H. Locker, learned additional public prosecutor. On perusal of the office note dated 6/3/2025, it appears that the notices issued to respondent number 2 has not returned. Stop. Await further. Stop. It also appears that the scanned copy of the trial court record, which was called for, has also not yet been received. Stop. Issue reminder for the same. List this matter again after 2 weeks.
My lord, I am S. Sengupta.
Instead of CH, S.
Sengupta.
Sengupta.
This is the 520 application for quashing of the charge sheet.
You have not taken
Yes,
steps.
Lordship, I have taken the step. This is the.
But the office note says.
Yes, Lordship. However, we have taken the steps on 24th, Your Lordship. Okay.
POCSO আছে না এই যে রেস্ট্রিকশন এই সব জয় সবিস্তার
Heard Mr. What is your name?
SD Roy, Your Lordship.
SD Roy, learned counsel for the petitioner. Also heard Mr. P.S. Lacker, learned additional public prosecutor. On perusal of the office note dated 6/3/2024-25, it appears that no steps for service of notice on respondent number 2 has been taken by the petitioner. Stop. However, learned counsel for the petitioner has produced the acknowledgement from the registry and has stated that he has submitted the return of notices for service to respondent number 2 before the registry on 24/2/2025 itself. Stop. You give a copy of this.
Yes, Lordship. I'm giving.
The registry to verify the same and list this matter again in the next week after appropriate office note.
Yes. Kindly date may be fixed, Your Lordship.
Next week on 19th March,
And can it be on 20?
20 March.
March.
Scan copy was called for Lordship of the law court records.
It has not come.
Lordship, meanwhile, I humbly pray for an interim order, Lordship. Because there is lots of delay in filing the FIR. Because the complaint was lodged by petitioner number 1 against the respondent number 2, and wherein because of that complaint on 17/10 Lordship 22, a disciplinary proceeding was done, inquiry was made, and subsequently direction was there from the SP to register a case against respondent number 2, and an inquiry was conducted, Lordship. Since that case was there and a simultaneously disciplinary proceeding was drawn against respondent number 2, subsequently in the month of December, Lordship, if he would have done the, in fact, petitioner number 2 was in the custody of respondent number 2, and wherein
he was brutally tortured. He was buried naked at the night at 2 a.m. by the respondent number 2. And he was badly tortured and with the
No,
photograph.
but these are questions of facts.
Yes, Lordship, this is
So,
the reason Lordship has called for.
Without
records.
going through records, how can we
Lordship,
verify?
I can understand Lordship, but
We
even.
are issuing reminder,
Yes,
fixing a
Lordship.
short date. Heard Miss Lee Ghosh, learned counsel for the petitioner. Also heard Mr. P.S. Locker, learned additional public prosecutor. On perusal of the office note dated 6/3/2025, it appears that the notice is issued to the respondents, private respondents. How many respondents are there?
Only one, Lordship.
Respondent number.
Private respondent 1. And
Private respondent has not yet returned. It also appears that the scanned copy of the PRC case number 92/2023 has also not been received from the dial code. Issue reminder for the same. Registry to issue reminder. And await for service report.
page,
Let
and
this matter be listed again on. You may suggest a date.
Lordship on 17th, soon after Holy Lordship.
On 17th of March.
Interim order may be considered on that day, Lordship. Page 91. Even the police and all this I have.
On that
annexed.
day, nobody knows who will be there. So you have to press again. If there is any urgency,
Yes, Lordship, there is urgency next prior to.
you can press for interim relief.
That will be,
That will not be reflected.
that will be reflected,
No,
Lordship.
no.
Because otherwise it's only because of personal vendetta. Since petitioner number 1 has lodged a complaint against respondent number 2.
No, but
Because
these
of
are
custodial
matters
torture.
of facts.
Yeah,
Unless
these
record.
are annex. Even the Police Accountability Commission has also ordered, and even disciplinary proceeding was drawn against respondent number 2 based on that torture. These all I have annexed, Lordship.
The question of interim relief will be considered on the next date fixed.
Deeply overread.
Interim document.
Appeal pending, my lords. Bail pending appeal now. Idea which came about 1.5 years back, my lord. That time it was rejected. Now, my lord, about almost 2 years, 6 months, more than 2.5 years now. So there is no chance of immediate hearing also, my lord. On that ground, only I have come.
You will file objection.
Your lordship, the copy of the IA is not served to us, your lordship.
You have already appeared.
I'm for the respondent number 2, your lordship.
Respondent number 2.
Oh, yes, he has appeared. POCSO is there.
Okay. In main case also you are appearing.
Yes, your lordship.
Main appeal.
Yes, your lordship.
Furnish a copy to them. Heard Mr. H.R.A. Chaudhary, learned counsel, senior counsel assisted by Mr. A. Ahmed, learned counsel for the applicant. This application under section 430, this section is wrong.
Page 17,
This,
19/7/23. Idea rejected.
This application for suspension of sentence imposed on the applicant by the judgment which has been impugned in the connected criminal appeal number 253/2622 has been filed by the applicant Akhirul Islam. Stop. Since learned additional public prosecutor has appeared for respondent number 1 and Mr.
IH Lashkar.
I.H. Lashkar is appearing for the respondent number 2. No formal notice need to be issued to the said respondent. The applicant is directed to furnish copy of this interlocutory application along with annexures
Today itself, I will file
to
it
the,
right now.
to the counsel for the respondent number 2 during the course of the day. Please this matter again on 17th.
17.
When
When it, next week, 17.
It
Let
will
me
be
add
after
it.
20.
Today we will give it, but let it come on the Thursday, my lord.
On 20, your lordship, otherwise it would be difficult for us to file any objection, your lordship. Definitely.
Objection.
let it be on 20th.
17, my lord.
You file by 17th.
We have to file also.
You will be also. Learned additional public prosecutor also submits that the state will also be filing an objection. Let this matter be listed again on 20.
20.
File your lordship.
May I please, your lordship. This interlocutory application has been filed for condonation of delay of 20 days in filing the connected appeal. Lordship, I have explained the grounds for the delay.
What is the offense?
Lordship, it is under NDPS Act, 6 months rigorous imprisonment has been made.
Only 6 months? Only 6 months?
Yes. Lordship,
Who is respondent number 2?
Respondent number 2 is the informant police officer. The subdivisional police officer, lead and subdivisional police officer of Titavur.
Human in delay, sir? Delay given?
23 days.
He may appear.
I mean, that can be condoned.
Condone.
Lordship, delay.
Okay. Heard. Mr. S. N. Tamuli, learned counsel for the applicant. Also heard Mr. P. S. Locker appearing for the respondent sides. P. S. Locker, learned additional public prosecutor appearing for the respondents. This application under section 5 of the Limitation Act 1963 has been filed by the applicants praying for condoning the delay of 23 days in filing the connected criminal appeal where the applicant have impugned the judgment dated 16/8/2024 passed by learned Special Judge Jorhat in Special NDPS case number 125/2021, whereby the petition applicants were convicted under section 20B2A small a of NDPS Act 1985 and were sentenced to undergo. What was the punishment?
Rigorous imprisonment of 6 months.
Rigorous imprisonment for 6 months. And fine was there?
Lordship, seized amount has been done. No, Lordship, there was no fine.
6 months. Stop. Learned counsel for the, where is the ground?
Lordship, in paras, it starts from para 3. Mainly the financial problem I have stated in para 4.
Learned counsel for the petitioner has submitted that the petitioners were mainly constrained, prevented from approaching this court for filing the connected appeal within the period of limitation due to financial constraints and other reasons which have been mentioned by the petitioner in paragraph number 3, 4, 5, and 6 of the delay condemnation application. So, learned additional public prosecutor, considering the grounds taken by the petitioner in their application, has fairly considered to the prayer for condonation of delay. In view of above, this court is of considered opinion that the petitioners are able to show sufficient cause which prevented them from approaching this court within the period of limitation. for filing the connected criminal appeal. Accordingly, the delay of 23 days in filing the connected appeal is hereby condoned. This interlocutory application is accordingly disposed of. The registry is directed to list the connected criminal appeal for admission in the next week on a date to be fixed by it.
Yeah, please, Your Lordship. Your Lordship, this petition is for condonation of delay, Your Lordship. The connected criminal revision has been filed challenging the judgment dated on 20 August 2024.
Notice will go. Heard, Mr. What is your name?
J. Kolita.
Heard
On behalf
Mr.
of
J.
Davis, sir.
Kolita, learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 has been filed by the petitioner, namely Prashanta Das, praying for condoning the delay of 27 days in preferring the connected revision petition by the petitioner. Issue notice to the respondents. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on the said respondent by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 4th of April. List accordingly.
May I please, Your Lordship. Should I seek for some accommodation, Lordship? I informed the other side. On the last occasion itself, the date was fixed today, talking with the court master, but we informed the other side that today, Mr. R.J. Das, the engaging counsel, he will not be here, Lordship. He's out of station. So kindly a date may be given, Lordship.
My only difficulty is that there's an application for vacating this stay, which is pending for 2 years.
No, stay is there.
Stay is
there. And your Lordship may see the stay order for a moment, Your Lordship. Don't mind.
In fact, Lordship,
There's
hearing
no
was there,
reason,
but
nothing, my lord, and your Lordship is aware of the Constitution Bench decision, where it said clearly that the applications for vacating the stay cannot be kept pending inordinately, my lord.
Yes.
but
If
the
I
thing
may
is,
be allowed
we
to
had
con-
already informed that today he'll not be here. The
They
existing
may,
counsel, Lordship.
they may argue whenever, my lord, it suits them, but let me at least point out my
Okay, they
grounds
have
for vacating the
filed,
stay.
they have informed and
Lordship, I had yesterday, on Friday itself, I had.
we will fix a short date.
Lordship.
I'm in my lord's hands.
You suggested it.
My lord, when I come from Delhi, is it possible, my lord, to address?
Oh,
to
you are
DC,
coming
my lord?
from Delhi?
Yes, my lord.
Then you can do it through VC.
Through VC. Any
Yes.
shortest convenient date then, my lord.
Heard Mr.
V.H. Chaudhary.
V.H. Chaudhary, learned counsel for the
On behalf of R.J. Das. my name is
petitioner submitting on behalf of our learned counsel, submitting on behalf of Mr. R.J. Das, learned counsel for the petitioner. Also heard Mr. P.S. Locker, learned additional public prosecutor, as well as Mr. What is your name?
A. Fukon.
A. Fukon, learned counsel appearing for respondent number?
For number 2, the private respondent.
Number 2. Learned counsel for the petitioner has submitted that has prayed for an adjournment on the ground that the conducting counsel for the petitioner, Mr. R.J. Das, has some personal difficulty today. On the other hand, Mr. A. Fukon, learned counsel for the respondent number 2 has submitted that the petitioner, how many petitioners are there? Only one. The petitioner has availed an order of stay in this criminal petition, and the respondent number 2 has already filed an application for vacation of the stay way back in,
April 23, 18th April 23.
you have filed then?
Yes.
Oh,
In fact, the hearing had taken place, Lordship, but due to paucity of time, it could not be concluded. Once the hearing was.
way back in the month of April 2023. And same stop. Considering the facts and circumstances of this case, it appears that since the petitioner is enjoying an order of stay of proceedings in his favor, and since since an application for vacating the said stay is pending for almost 2 years, same is required to be heard and disposed of at the earliest. However, as the conducting counsel for the petitioner is not present today, this court is constrained to grant the prayer for adjournment. The
Question if it can be tomorrow, I can stay back then, but they have some difficulty tomorrow.
Not tomorrow, Lordship.
when
After Holi, Lordship.
after
per his-
you suggested it,
My lord, on 21st, my lord, of March.
let this matter be listed again on 21st of March. Since the counsel for the petitioner, as counsel for respondent number 2 is an outstation counsel, he has prayed that he may be allowed to address this court through video conferencing. A separate application দিব লাগে নাকি link or কারণে? You have to file an application for providing you with the link.
We will do that.
The petitioner, the council may file an application before the registry so that link of the video conferencing facility may be provided to the respondents, to the said council on the next date fixed. List accordingly on 21/3/2025.
The interim may kindly be continued.
The interim order shall continue till next date.
Deeply obliged.
Obliged, deeply obliged.
Petitionary appeal, Lordship.
This is appeal against conviction, measure. Convicted under section 10 of POCSO Act, RI for 5 years. So at this stage, Lordship may admit the appeal and the notice will be issued.
Yes.
In I approved.
Heard Mr.
A.K. Gupta.
A.K. Gupta, learned counsel for the appellant. This appeal under section 415 of the BNSS, 2023 has been preferred by the appellant Dilip Devnath, impugning the judgment dated 18/12/2024, passed by learned additional session judge, special judge POCSO, Tinsukia in POCSO case number 62/2022, whereby the appellant was convicted under section 10 of the POCSO Act, 2012, and was sentenced to undergo rigorous imprisonment for 5 years and to pay a fine of rupees 10,000, and in default of payment of fine to undergo further rigorous imprisonment for 4 months. Issue notice to the respondent number 2 in pursuant to the prevailing notification in this regard. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to the said respondent. Admit the appeal is admitted. Stop. Call for the case record of POCSO case number 62/2022 from the trial court. List. The petitioner. petitioner shall take steps for issuance of notice on respondent number 2 within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
But there is also IA, my lord.
In IA also, this interlocutory application has been filed by the applicant for suspending the execution of sentence imposed on the applicant by the judgment and order which he has impugned in the connected criminal appeal number 62/2025. Issue notice to the respondent number 2 in as per the prevailing notification in this regard. The applicant shall take steps for issuance of notice upon the respondent number 2 within 7 days from the date of this order, returnable after 4 weeks. As learned additional public prosecutor has already appeared for respondent number 1, no formal notice need to be issued. List accordingly.
Okay.
24.
May I please, Lordship. Lordship, this is appeal against conviction, Lordship, and the appellant was convicted for 5 years under section 10 of the POCSO Act, Lordship.
Same order.
Same order. Sign it. Lawyer's name is Mr.
N. Hawk.
N. Hawk. Issue notice. Same agonists order within a week, returnable after 4 weeks. Case number available.
Lordship, I is also the.
I also we are issuing notice
Lordship.
after 4 weeks.
May I please? But by this petitioner praying for Jimma will not improve vehicle. And it was taken into police custody with effect from 18/2/2024. As in today, 1 year already over. So we are before this one will court that that vehicle may be released. Page 25 is the Jimma rejection order.
Whether any report has come.
No, so instead of report, Lordship, the IO has sent one report that the case has been charged, Lordship. That much we have.
Maybe vehicle may not be necessary now. That may be real.
What is the offense?
Offense is 395, that I think. Session tribal method.
What is to be done? You approach the trial court.
Lordship.
Because trial court may be knowing.
Yes, my lordship's correct.
We don't have any facts.
Well, another round may be waited. As because already 1 year is over. In Sundarbhai Ambalal Desai, as per Sundar.
We will give observations that it has to.
Because another round is there. Until and unless commit the matter, they will not release the vehicle.
Heard, Mr.
K. Rahman.
K. Rahman, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner, namely Babul Ali, impugning the order dated 6/8/2024 passed by
JFC Morigaon.
Passed by learned judicial magistrate first class Morigaon in IA within bracket Jimma number 258/2024, whereby the prayer for Jimma of the vehicle bearing registration number AS01 BB 1637, which was seized in connection with the
In connection with Dharmatul PS police station case
in
number.
connection with Dharmatul PS case number 8/2024 under section 395 of the Indian Penal Code was rejected by the said court. Learned counsel for the petitioner has submitted that you earlier also approached this court,
No, my lord, this is the first time.
has submitted that the petitioner is the
That is
registered,
bail order, my lord.
petitioner is the registered owner of the vehicle bearing registration number AS01BB1 AS01.
Yes, sir.
What is the number?
S01/BB1637.
1637, which was seized in connection with the said case. Stop. In support of his submission, he has produced the registration, a copy of registration certificate of the said vehicle. Learned counsel for the petitioner has submitted that his vehicle was seized on
My lord, 18/2/2024.
18/2/2024, and since then same is lying in the campus of the
Police station.
which police station?
Dharamtul.
Dharamtur police station
In
under
the
open
district of
sky.
Morio.
Where is Sundar Bhai Ambarlal?
Sundar, we have quoted the valid paragraph. There is para 6.
Learned counsel for the petitioner has
Para 6 of the petition.
submitted that the vehicle is no longer required for the purpose of investigation or trial. However, same is lying under open sky without any maintenance. And as the petitioner is the registered owner of the vehicle, he may be granted the Jimma of the said vehicle in view of the observations made by the apex court in the case of Sundar Bhai Ambalal Desai versus State of Gujarat, reported in AIR 2003 SC 638. On the other hand, learned additional public prosecutor has submitted that though a report was called for from the investigating officer as to whether the vehicle in question is further required for the purpose of investigation. However, in the meanwhile, charge sheet has already been submitted in the said case. You have charge sheet number?
Height CS number 02/25 dated 18/1/25.
18/1/25. As the charge sheet has already been submitted, this court is of considered opinion that the further retention of the vehicle under open sky would be a futile exercise. Stop. If for the purpose of trial, the vehicle in question is required, same may be ensured by imposing sufficient conditions on the owner of the vehicle, that is the petitioner. In view of above, the the officer in charge of
Dharamtul police station.
Dharamtur police station is hereby directed to grant the Jimma of the vehicle bearing registration number
AS01.
AS01 BB. What is the number?
1637.
1637,
Yes,
which was seized in connection with Dharamtul PS case number 8/2024 to the present above named petitioner, to the petitioner namely
Babulal.
Babul Ali, who is the registered owner of the said vehicle, after verification of the documents to be produced by the petitioner before him stop. At the time of granting Jimma, the petitioner would be required to furnish a bond of rupees. What is the cost of vehicle?
Your phone.
How much?
Around 5 lakh.
4-5 lakhs.
Bond of rupees 5 lakhs. With a condition that he shall not alienate the said vehicle without leave of the court and shall not make any material alteration in the said vehicle without informing the court. Stop. He shall also give an undertaking to produce the said vehicle before the court in the trial as and when required to be required by the trial court. The bond furnished by the petitioner before the officer in charge of Dharamtul police station shall be forwarded by the officer in charge to the trial court to be annexed for annexing the same with the records of GR case number 168/2024. With above observation, this application is here, this criminal petition is disposed of.
Complaints.
Regarding item 4 lordship that they have said they have to place the judgment in lordship, they have not placed that one.
Bulwa is there.
He's searching the judgment, but he's not here.
I will fix a date. Day after tomorrow.
Tomorrow,
Can I be the CAV lordship because my party is over lordship?
No, it is only a matter of counting. Is it whether the 180 days is complete on 15th or 14th?
Arithmetical calculation says lordship it is complete on 15.
But his arithmetic calculation says it completes on 14th.
So we're gonna fix it on day tomorrow, day after tomorrow, so he will satisfy.
Because the judgment which I have placed lordship, they say it will be complete on the midnight at 12 AM.
Okay. Kunil is in dictation. No dictation, this one. Part dictation. I have dictated in part.
Yes, Lord. 80% already covered, Lord.
Yes.
Only that person part of it. But that
Burrow will come.
He has gone for searching that order received, it has been received.
He said that he will be furnishing SCC all night. Tomorrow I will deliver the order.
Yes.
After Barua submits that.
Only the placing of that judgment, Lord, which is
Tomorrow he will.
Yes. Delivery of order.
Yes.